Good afternoon. Welcome to the Appellate Division, First Department. As I call the calendar today, please ask for the time you actually need. We've got almost 6.5 hours of argument time requested, which we would not be able to do. Remember, if the panel has additional questions, you'll pass the time that you've been allotted. We'll ask the questions and you'll have an opportunity to answer. We've read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that when the white light goes on the lectern, you'll have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know how much time you are requesting. People v. Taquan Johnson, submitted. JDM Washington v. 90 Washington Street.
Appellant requests 8 and 2 for rebuttal.
Respondents request 7 minutes.
6 and 2 and 6. C. Jupiter, submitted. Sorantis versus Tisch, submitted. Healy v. Trinity, that matter's been adjourned. South Shore versus First Class Products.
The House requests 7 minutes for opening and 2 for rebuttal. Respondent requests 7 minutes, Your Honor.
5 and 2 and 5. People versus Taiwan, Austin, submitted. Alonzo v. Cabgram.
Plaintiff appellant respondent requests 3 and 2, please, Your Honor.
Do you have a cross appeal? Yes. 5 and 2 and 5 and 2. BML Properties v. China Construction.
Respondents request 6 minutes.
7 and 2 and 6. Goldstein v. Berenbaum. 6 and 2 and 6. Ada v. 450 West 131st Street.
The other appellants, Your Honor, request 5 and 2. And the green appellants, co-appellants, 2 and 1.
2 and 1.
8 minutes for respondent, Your Honor.
Okay, 5 and 1 and 2 and 1 and 7. DivX v. Harmon.
Your Honor, defendant, appellant, respondent, Harmon requests 8 and 2.
Respondent cross-appellant requests 8 and 1.
I'll give you both 7 and 2. Thank you. People v. Freddie Ferrera. 5 and 2 and 5. Brown Clark v. City of New York submitted. Kayem v. City of New York submitted. Okay, first case up is JDM Washington.
May it please the court, I'm Norman Flitt, and I'm arguing here to vacate an order that violates both the precepts of Yellowstone jurisprudence and the standards.
This Yellowstone had several birthdays, didn't it, Mr. Flitt?
This Yellowstone had 2 birthdays in the Supreme Court. It was issued for 6 months, renewable on good cause. We showed good cause. It was issued again. We took an appeal arguing that it's not appropriate to have a Yellowstone injunction for only 6 months. It has to endure for the entire duration of the case so that the tenant can litigate whether or not there is a default to be cured without endangering the leasehold. We have a $400
Counsel, you
million
received that,
leasehold
right?
here.
You received that, and the deadline, you received that deadline until the end of the action, right?
Yes, by this court's December 28, 2021 order, the Yellowstone, which we timely applied for in the first instance, was made retroactive to November 22, 2019. So Supreme Court's findings that the Yellowstone injunction expired on May 3, 2021,
Let's assume that we agree with you, counsel.
Okay,
For the sake of argument, let's assume that we agree with you. Then let's talk about the breaches that are at issue here. This building was deemed unsafe in 2010, and the cure was effectuated in 2024, 14 years later, and 3 years after you received an extension of the Yellowstone injunction from this court. I was on that panel.
yes.
You explained to me why you warranted us, why you did not breach your lease.
Okay. What we're dealing with are the particular lease violations set forth in that August 2018 notice of default. And let me just say this, neither side looks
Are
good
you
here.
answering my question,
Yes.
counsel? Because there were 2 stop work orders, and my understanding is, according to the record, work continued, notwithstanding the stop orders. Also, work continued without a permit. What are we talking about? Why is your client not in breach of the lease?
Because we cured all of the violations and we got a sign off for the paneling. And what we're fighting about here is methodology. They didn't like the aluminum cladding. And that's like the elite.
With respect to the
wine and
aluminum
spirits
cladding,
place.
with respect to the aluminum cladding, my understanding is, again, are you able to hear me? According to the record, there was mesh missing behind some of the aluminum cladding. There were anchors missing to affix the mesh to the brickwork, which was not actually repaired. Only aluminum cladding was done on 3 sides. The rear was left with the brick exposed. What are you talking about, counsel? You still haven't answered my question as to why your client isn't in breach of the contract.
Well, let me say this.
No, you need to answer my question.
Okay. Our client did whatever it could to address the mesh, to address the landlord's considerations. And I tell you, this court's rulings, like the Quick Park v. 808 Columbus case, once a Yellowstone injunction is obtained, as we did here timely, the tenant can actually do nothing. And if there is
Since when?
since Quick Park,
Since when? You get a Yellowstone injunction, and it's a measure of, it's a remedy in equity.
yes,
It gives you a chance, or whoever the applicant is, gives you a chance to come up to code.
No.
Okay? Come up to speed, cure violations. 14 years. Was the building occupied during the period from 2010 until 2024, when the certificate of completion was issued by DOB?
I don't know between 2010 and 2018, but I believe after that it was tenanted. And
And there was some type of restaurant downstairs, right?
I wouldn't know.
According to one of the photographs in the record, the restaurant downstairs, notwithstanding the fact that there was a local law 11 violation that had not been cured, and there was a brick that came down off the building, almost killing somebody, according to the emails issued internally. So how can you say that there was no breach of contract here, no breach of the lease?
Okay, let's agree with you and say there was a breach of the lease. The purpose of Yellowstone is, even if there is a declaration that you're in default, that you have the opportunity to cure. And that
So, counsel, let me ask you, we both agree, right, that there are some things that one might call a default on that can't be cured, right?
Yeah.
And if those are not cured, doesn't matter whether you have a Yellowstone or not. So one of the things in the 2018 30-day notices, failing to deliver to the landlord copies of all required permits prior to commencing any capital improvements. Did you do that?
I don't believe we did.
So then, and that's not curable, right?
Well,
Not curable, default of the lease. So how do you explain that default of the lease?
the facts were what they,
Let's agree. Do you agree with me that's a default of the lease?
I do,
And it was in the 30-day notice to cure.
yes.
And it doesn't matter how many Yellowstones you get, if you can't cure a default, you've defaulted under the lease, correct?
However,
Well, let's just start with
I
yes.
think if you
Yes. I mean, I can
redo,
go through
if you
3 or
strip
4
the
more
work and
things.
redo the job and re-permit it, you can cure without vacating the premises. And that's what
If you can cure, but there are things that are not curable that are in this 30-day notice of default that no one ever looked at from 2018, and now at the end, the court said you could not cure that, and therefore it's a default, and your lease is over. And you're not disagreeing with any of that.
Actually, I am.
Tell me what you're disagreeing with.
I'm disagreeing with the fact that the lack of a permit is a default that can't be cured. I'm disagreeing with the fact,
Lack of a permit prior to commencing any capital improvements. That's exactly what the lease says. That's exactly what your obligation is. I asked you 2 minutes ago, did you do that? Did you give the landlord all required permits prior to commencing work? And you said no, correct?
there was a structural permit that they didn't give them.
Okay.
And with
Counsel, I'll give you 30 more seconds, then you got to sit down.
Okay,
You'll have time in rebuttal, of course.
okay.
No, I'm saying you can have, if you want to finish the thought, you have 30 seconds.
The thought is as follows. No one looks so good here. The landlord from 2010 to 2018 did nothing. Then we had the Yellowstone toll when the tenant could do nothing, had the right to do nothing. And instead, the tenant tried to work with them and did work with them until it became evident that you couldn't satisfy them. And then the tenant did what it's entitled to do, let the court decide. Now, you don't go into a Yellowstone even if you're held in flagrant.
Thank you, counsel.
and lose
You'll
the
have more time in rebuttal. Thank you very much.
Thank you.
Good afternoon, Joshua Bernstein from Ackerman for the respondents who collectively are the landlords under the long-term triple net lease at issue on this appeal.
Counsel, your colleague, your adversary, said just now that the landlord did nothing, and similarly, the tenant did nothing. Was the landlord remiss here?
Landlord was not remiss. Remember, this is an out-of-possession fee owner of the building who has, first of all, no obligation to the lease, but more than that, there's no evidence that they had any idea of what was going on with the facade. In other words, for years, and the evidence is that when they learned, they immediately raised the issues with this tenant. More than that, Your Honor, I want to correct a couple of things that came up during your questioning of
Please.
Mr. Flitt. Number one, there is no cure of these defaults. These defaults have not yet been cured. I understand that Your Honor, that Mr.
Certificate of completion is not dispositive?
The certificate of completion is not
To
dispositive.
what extent, please?
Because in order to lift the local law 11 violations on this building, the tenant has to have an engineer, a qualified exterior wall consultant, file a FISP report demonstrating that the facade is now safe. That has not happened as of the time at trial. And as of today, it has yet to happen, even months after trial.
So the certificate of completion did indicate that self-certification would be allowed. And what you're saying is that that did not happen.
That does not lift the local law 11 violation. What lifts the local law 11 violation is the filing of a FISP report from an engineer who's qualified, certified, licensed by the state that certifies that the facade is now safe. The testimony at trial was that it had not yet been issued,
I
and we just
understand.
checked, and it hasn't been issued as of now.
What other issues?
So the other issue that I wanted to raise is this idea that there's anything curable here. In other words, the reason why, and this goes back to Justice Scarpulla's questioning relating to the lack of a structural permit, the reason why that's incurable is not just because they didn't get the structural permit, which itself is a default and an incurable default because it was needed before construction began, but more than that, their structural engineer, OJR, filed a structural job application with the Department of Buildings in the months before trial, knowing that they needed to get that sign-off that's not really a sign-off from the building department so they could come to trial and claim that they had cured the day before, but knowing they hadn't pulled the structural permit for the massive amount of structural work on this building. I mean, we're talking about a massive amount of cold-form steel framing that was attached to the exterior.
You're aware of that.
I apologize. I apologize, Your Honor. They withdrew the structural job application so that the building department would not know that there was any structural work, unpermitted structural work, on the exterior of this building that had been installed as part of this job. And what their structural engineer testified at trial was that tells the building department no structural work was done. It's as if it never happened, which means
So several site managers quit. They had, I believe, a progression of 3
that's right,
at minimum.
at minimum.
Did that have any effect on on curing the violation?
It certainly had an effect. I mean, it stopped work. This is after this court's decision in 2021, which I know Your Honor was on the panel for. It stopped work for a period of, I think, about 11 months while 3 different stop work orders were issued by the Department of Buildings for the lack of a site safety manager on site. And they were unable to do anything. And even after that was lifted, they didn't go up to the top of the building, take off the panels, and fix those gaps in the mesh. Instead, their own principal, Joseph Moynihan, on direct examination, this was not cross-examination, this was elicited by the tenant on direct examination of Mr. Moynihan, he testified he decided not to cure these gaps in the mesh that hold the failing brick back and prevent them from knocking into the aluminum cladding. He decided not to do it because he thought it wasn't worth it, because he thought it was too expensive and not worth it, and so he covered it up. And instead, he withdrew the structural job application that their structural engineer had filed and pretended like no structural work had been done. Also, we could come to trial and claim that the defaults had been cured.
Counsel, let me just ask you one thing. Wasn't, counsel, your adversary stated that nothing happened between 2010 and 2018. I thought in 2013 there was some activity.
2013, they entered into, 2012 actually, they entered into the first contract for the facade work to remedy the local law 11 violation. That remedy was going to be the repointing and replacement of all the failing brick around the circumference of the building.
And that didn't happen ever.
That never happened.
And 2025, it still hasn't happened.
2025, it still has yet to happen. That's correct, Your Honor.
So my recollection from 2021 was that the onset of the COVID pandemic played a role in delaying the remediation of the violation. Did that affect remediation after the pandemic after the orders were lifted?
No, it did not. And in fact, that was never accurate. In fact, there was no evidence presented by the tenant at trial about COVID delaying anything. Instead, and I know my red light's on, if you'll just let me quickly finish this thought. Instead, what the evidence was, Your Honor, was that they, I'm sorry, I lost my train of thought. You have it in our papers. I'll rest. My red light's on. Thank you for your time.
Thank you, counsel.
Very briefly. In the Warden Binkley case that Justice Higgett wrote, it was stated that this court errs on the side of granting equitable relief. Here, the issue that was really before Supreme Court was never addressed. Did this tenant, between the service of the notice to cure in 2018 and the tolling of the Yellowstone injunction, 540 days later, earn the extended cure period, which should be continued? Now, we didn't get
Are
that.
you asking whether the panel that signed the extension, the Yellowstone extension in 2021, should be sorry for having given your client an extension?
Actually, no, because you followed the law. And that's what I'm asking you to do to save a $400 million asset. It's an ugly case, I admit. Neither side can stand here proud and say we did a great job for this building or the tenants in it.
I'm curious as to why you said earlier that the owner was remiss with respect to the remediation of the violation. I don't understand.
With respect to what we had here, you had 2010 to 2018, nothing happened. They
So what did
claimed
the
they didn't know
owner,
about
what did the
it.
owner do wrong? You said they were remiss. What did they do wrong?
When an owner is faced with a situation where a tenant abuses a Yellowstone injunction or, as the owner claims here, continues to breach, they have two things they can do. Number one, they can serve a notice to cure, which they did not. They didn't serve a subsequent notice to cure and were being held in default by Supreme Court for things that were untriggered events of default. Two, and I've represented a lot of landlords, you make a motion to vacate the Yellowstone injunction and get injunctive relief to make the tenant conform, comply, and do something. This case started in 2019. COVID notwithstanding, we did work. We complied with conditions that Justice Cohn had. And then you have a trial in 2024, and they do nothing between 2019 and 2024. If it's such a wonderful, great, horrible situation, you move on it.
Thank you,
And,
counsel. Are there any further questions? Thank you very much. Thank you both.
Thank you.
South Shore v. First Class Products. Please.
Good afternoon, Your Honors. Gavin Rooney on behalf of the defendant appellants, Todd Coven, Magda Apt, and First Class Products. We appeal from a judgment entered following a bench trial. We're focused on two issues in this appeal. The first is the finding of fraudulent inducement, which led the trial court to award as damages all of the plaintiff's business losses. And secondly, the finding that our conduct was willful and material, thereby rendering my clients liable for attorney's fees and interest. That was, of course, dependent upon the fraudulent inducement claim as well as the alleged failure to disclose a $5 fee in connection with the ice cream. Let me start with fraudulent inducement.
Let me ask you this about both claims. The $5 markup, isn't that game over for you?
No, it's not game over because one of the things is materiality. It needs to be willful and material. That's the statutory language. Each of the plaintiffs testified that the $13.50 that they paid for the ice cream was less than the market price, the similar wholesale market price for the ice cream.
So, counsel, didn't each of the plaintiffs say they would not have entered into the agreement if they knew that what you were telling them, which is you were just passing the ice cream through at cost, was false? Did not each and every one of them testify that they wouldn't have entered into these franchise agreements if they had known that?
They did testify.
And so if the trial court accepted that testimony as true, isn't that sufficient to, under the act, to prove your liability?
Respectfully, no, because I think materiality needs to be judged by an objective standard, not a subjective standard. And I think looking at other contexts, the law has been clear that we need to view it from the standpoint of an objective investor. So the question really becomes, in a situation where $13.50 is less than the market price.
You don't think that telling a 60% markup from the your client falsely represented to those franchisees that they were getting the ice cream at cost and they marked it up 60%. You don't think that that's a substantial misrepresentation?
Even from an objective standpoint? Because it's 60%.
Well, recognizing my clients in their testimony denied that those representations were ever made.
But the court made credibility determinations that we are not going to go back on.
I understand, Your Honor. But I think from an objective standpoint, you require more than simply a question to a self-interested plaintiff. Would you have entered into the transaction had you known? Answered no. That's what's in the record.
But we also have the objective fact that the trial court found that your client marked up the ice cream by 60%. Right? The trial court found that testimony to be true. So that, coupled with the witness's testimony that had they known that, you're saying still wouldn't meet the standard.
It would not, because it's not on an objective level. If you're going to go out and buy the ice cream in the market generally for $13.50, and that's a fair price, and you're willing to do the deal with that price being paid for ice cream, why would
But the
that change
testimony
your
was that they were not willing to do the deal with that price.
I'm saying from an objective standpoint of an objective investor, not the self-interested testimony of the plaintiffs, but an objective investor.
So
they're
you're
willing-
saying, and just so that I'm clear on what you're saying, is that an objective investor would have been willing to pay 60% more for a product?
An objective investor would be willing to pay $13.50 per gallon for ice cream, which was less than comparable ice creams that could have been bought at wholesale from other suppliers.
Counsel, you also have to think about the rest of the context of the pitch. You know, that these stores were pitched to them under the very optimistic business, the Aventura plan, is that what it's called, which is based on a very lucrative store in Florida, which was not typical. And so they're evaluating what their costs are going to be and what their asset, you know, what they're going to realize from the store in that context.
Yes, and with respect, Your Honor, that was a projection. It was not a report of actuals. There was no evidence in the record that the projection was false.
Stop. What about the email dated November 17th, 2009, where Mr. Coven stated, in order to sell this to others, Magda and I need to set up a mock spreadsheet. In order to do this, we need to know how many gallons ice cream from Aventura buys from you a year or any other high-volume store. Then we can backtrack and fudge numbers to show that the store makes real money. And the response from Mr. Corsover was, the one word we never want to use is fudge. The word we want to use is project. How does that play into what you're saying?
There's nothing in the record to connect that email with the Aventura business plan that was given in 2011 to Wes Caldwell. As Your Honor just noted, that was November of 2009. If you look at the attachment, there is a different document attached there with different numbers, different projections, not what was given 2 years later to Wes Caldwell. So that's an email taken out of context that doesn't connect itself causally to a different document that was prepared 2 years later.
If we could just go back to the ice cream markup, wasn't there a February 9th, 2011 email from a DEI principal raising red flags about the $5 markup, and then maybe the language had to be changed?
Yes,
avoid
what the person was saying is that if you look at the contract, it says either first class or supplier will charge the $13.50. So if you look at it from that perspective, if first class, that's my client, was actually the person charging the fee, then obviously the plaintiffs would know the fee was going to first class. And they wouldn't necessarily know what the cost basis was of the ice cream and whether first class was making a profit or not. So and that's what each of the contracts say. So if you look at it from that perspective, I don't think it's a false statement or a misleading statement. They're truthfully told what they're being paid, what they're paying for the ice cream. They agree in the contract that they can simply pay first class the $13.50 without any discussion of what the cost basis might be.
Thank you, counsel. You have time in rebuttal.
Thank you.
May it please the court, Russell Morris for the respondents. Starting with the first point that my friend on the other side discussed, materiality of the markup. I think the record is abundantly clear that the markup is material.
Counsel, put the microphone a little closer to you, please.
Sorry, I think the record is abundantly clear that the markup was material, both objectively and subjectively. Had they not found out about the markup in time to limit the markup damages, they would have ended up paying an order of magnitude more. I mean, the email from Jerry Corsover at record page 1263 notes that they could expect possibly to get more than $300,000 in markup from each franchisee over a period of 5 years. So that is
Counsel, can we talk about reliance for a minute? Because that is an element under the Franchise Act, correct?
absolutely.
Okay, so was there reasonable reliance here, given the very impressive educational qualifications of your clients?
Absolutely. Your
Even though they didn't have a degree in ice cream, they had pretty fancy degrees.
Justice Moulton, I'll address the question of reasonable reliance. How could my clients, who were generally smart people, have trusted the defendants and reasonably relied on these oral statements? Well, the narrative came out at trial. I'll begin with Nina Shores, who did South Shore, and Heidi, who did Smithtown.
And when you do that, can you just talk about why they exercised no diligence in following up and getting any paperwork regarding projections or financials?
Absolutely, Your Honor. So, but to set the stage, they meet the defendants. And Defendant Cohen is a doctor. He lets you know he's a doctor. In footnote 3 of their papers, they mention that Dr. Coben is a board-certified Mohs surgeon, a doctor who removes skin cancer. So in what world does a board-certified Mohs surgeon lie to you about the revenue he's receiving at the ice cream shop that he opened up as a side?
Counsel, we're talking about your clients.
Yes. Well, so as Ms. Gans-Bonhurst testified, I'm a physical therapist. He's a doctor. I listen to doctors all day long, so you believe who they are.
So you trust them with regard to ice cream and a franchise just because they're a doctor?
They
And
were
you
very-
ask for no additional paperwork or no follow-up regarding the financials? Is that reasonable?
I agree with you that you know, was unfortunate. But what constitutes reasonable reliance is case specific.
So let me ask you, was there any real way to figure out the markup on the ice cream as opposed to the because the projections, you clearly could have looked at public information, but the ice cream markup, was there any possible realistic way of discovering the falsity?
Absolutely not, unless, as Jerry Koshover said, we went down to Florida and took his deposition. So there was no way to find that out. But with respect to trusting these particular defendants, not only was there the imprimatur of Dr. Coven, but when you look at Ms. Garman, she was close personal friends with Magda Apt. They worked together for 2 years. Magda called her, I mean, there was a generational difference, and Magda called her big sister or her work mother. She took her to a pole dancing class. That's something you do with a very close personal friend. And so Robin believed Magda. We believe our friends. So could any of these plaintiffs had, followed up and say, could you show me some documents? In a perfect...
What about creating their own budget? Like their own budget for the store in terms of what things would cost, how much revenue they could get? They do any of that?
Well, Your Honor, even if they had created a budget, a formalized budget, they would still be relying on these false income projections. That was the big meat and potatoes. That's why they opened these stores. So, in a perfect world, should they have asked for the backup? Yeah, but in a certain sense, in the Franchise Act world, doesn't it turn the act on its head to put the onus on the franchisee to get these backup documents? The Franchise Act is there set up to make the franchisor give truthful, accurate statements. I mean, the requirements of the act.
Yes, but I mean, still, counsel, our case law requires some reasonableness, right?
Yes, I mean,
So that's I think what my
arguably
colleagues are asking you. Is it reasonable not to look at any numbers, not to look at any public documents? That's why I think it's a different story with the ice cream, because I don't know how one would be able to easily find that information out. But aren't all these stores filing documents?
No, Your Honor, these are not publicly available.
No, aren't you asking? I think your clients asked for documents and then never got them and never followed up, right?
Because they didn't exist at the time. Your Honor.
Okay.
But if I may briefly say, even in the cases that my friend on the other side cites, the question of what constitutes reasonable reliance is nettlesome and fact-intensive. And Justice Kelly looked at these witnesses, heard them testify, and he decided that their reliance, even though it may have been misplaced, was reasonable under the circumstances.
Thank you, counsel.
Thank you, Your Honor.
Just briefly, Your Honors, on the issue of reasonable reliance, one thing I did not hear my friend on the other side address is the fact that Wes Caldwell, who received the business plan for projecting $1.5 million in revenue per year, also received word from another individual, Jeff Radoff, who met with the original franchise owner in Florida and reported to her that most she could expect in year one is $375,000. And she wrote
She admitted
off.
that on cross, right?
She admitted that on cross, and she said in her email, this is nothing more than Wharton MBA negativity, and I'm not paying attention to it. So I can't imagine more of a big red flag for someone before they go forward than receiving that.
But if we
After
agreed
Mr.
with
Radoff
you-
did the, I'm sorry, Your
If
Honor.
we agreed with you on your reasonable reliance point, wouldn't we be undermining the underlying purpose of the franchise law, which is to improve the quality and quantity of information that are out there? It doesn't seem to me that the act is meant just to protect economic rubes. It's meant to protect anyone who's going to become involved with a franchise model.
Well, we're not here challenging this court's earlier decision that we had a franchise and we had to file the offering memorandum and whatever damages that may lead to, which I think is the reversion of $50,000 franchise fee that each of the three plaintiffs paid. So we're not challenging that, but fraud is a different animal, and there is certainly the anti-fraud provision in the Franchise Sales Act, but there I think we need to apply the same standards of reliance that we apply in other contexts, and that's what this court has done in the past as well as what the Southern District has done. And then on the ice cream issue, I'll make one more pitch at my materiality point, which is from an objective basis, it amounts to $9,000 if you just refunded the money per plaintiff, or $27,000 in total.
Each of them lost their stores, right?
I'm sorry?
Each of them lost their stores. The stores all failed,
Not because of the ice cream pricing.
not because of the ice cream price.
There's nothing in the record to suggest that that $9,000, if you went back in a time machine and gave it back to the plaintiffs as they were running their stores, that they would have been profitable and
Well,
they would have
what's in the
succeeded.
record is that they would not have purchased a franchise if they knew that. That's what's in the record. They wouldn't have had an ice cream store.
And what is the remedy? What's the penalty under the Franchise Act? Isn't it more than that?
Well, I think the penalty would be to refund them their the $9,000
That's the remedy?
apiece for what they paid for the ice cream. Thank you, Your Honor.
Thank you. Thank you both. Alonzo v. Cab Grand Developer. Please.
Good afternoon, Your Honors. Anthony DiStefano for Plaintiff Appellant Respondent. My client clearly indicated that a scaffold board fell from above him and struck him on his hard hat before the two-level Baker scaffold that he was building with his coworkers tipped over and struck him on the forehead. Standing alone, that testimony would be enough to establish liability under Labor Law 240 sub 1. It is of no moment that my client then testified that he was told by his coworkers why the board fell and why the scaffold tipped over. The board fell because they dropped it. The scaffold tipped over because they were trying to prevent the board from falling and striking my client. Under well-established law in this court, my client does not need to establish precisely why the board fell or the scaffold tipped over. It is enough that there was a lack of securing of both that caused this accident.
Was his back turned at both in collisions with the board and then with the scaffold? Was his back turned at those?
I believe his back was turned when the board fell and struck him on the top of the hard hat, whether he instinctively turned and then was facing the scaffold at that point when it tipped. But there is no dispute that the scaffold tipped. In fact, the defendant's witness testified that that is what he was told after the accident, that the scaffold did in fact tip over.
So is it the fact that a scaffold tips over or collapses indicative of automatic liability? Is it res judicata?
Well, under this court's decision in Hyatt versus West Development Court, there was a similar situation in which they were actually dismantling the scaffolding instead of building the scaffold when the scaffold tipped over. And this court found, as plaintiff established, that he was injured as the result of a failure to provide with an adequate safety device as required by the statute. The plaintiff was in fact entitled to summary judgment. So under that case, Your Honor, I would suggest that it would be enough that the scaffold was capable of tipping over, especially a Baker scaffold. Certainly, they're not supposed to tip over. They are supposed to remain erect.
I believe the defendants take issue with the height of the scaffold. Is that dispositive in any way?
No, it would not be, but they agree also that it was a two-level Baker scaffold that has to be at least 12 feet. So under either my client's testimony that it was 16 feet or their client that it was, I believe, 14 feet, he said, it would still be enough. It's also of no moment that my client was standing on the ground when he was struck. The Court of Appeals has eliminated the same, so-called same level rule in the Walensky case, and it is not enough that the board was being handed to my client's coworkers, as this court has routinely rejected the argument that materials being passed by hand are also not subject to the requirements of Labor Law 240(1). Unless the court has any other questions. Thank you.
Thank you, counsel.
Good afternoon, Your Honors. Jerry DeCamp for the respondent appellant, Capgram Developer LLC. We do take issue with the facts in this circumstance as compared to the cases that were put in support
Counsel,
of.
this was a scaffold that collapsed, right?
It did not collapse, no, Your Honor. The scaffold tipped. There was nothing wrong
Did
with
it
the
fall
scaffold.
down to the floor onto the plaintiff?
Plaintiff did not see it. And
Does it matter? I'm asking you about what happened with regard to the
I
scaffold.
believe it does. It depends on whether or not the safety
Did a
device
scaffold fall
failed.
and hit him on his head?
It tipped according to what his
It tipped
coworkers
and
told
it
him.
fell on him, right?
That is what his coworkers told him after the fact when they went to visit him.
Counsel, did they find the scaffold on top of the man?
There was no testimony as to that because the two coworkers, the painters, he can only identify them by their first names, and the employer did not have any information with respect to last known addresses, so they never testified.
One
in that
second,
fashion.
didn't he testify to that?
He testified.
Oh, yeah, there is testimony to that. It's his testimony.
He
He
testified he
said,
wasn't 100% sure on what occurred.
doesn't
then
matter,
was
but
later
he
told this.
testified that the scaffold was on top of him, correct? And that his coworkers pulled it off.
He-
You agree with that?
Okay.
Okay, so there is unrebutted testimony by anybody else. You could have gone to the two coworkers there or anybody else. So the unrebutted testimony is that the scaffold fell on him and was pulled off of him. So now what?
Well, the fact of the matter is the plaintiff hasn't shown that the safety device failed. They were in the process of putting it together. It was defect-free. They checked every component part. They had done this
Defect-free,
50 to
but for it
60
having fallen on top of him, right?
I'm sorry?
It's defect-free, but for it having fallen on top of him.
But it didn't just fall or collapse. Everything that's cited to by the plaintiff, a collapsing scaffold where component parts were missing, something was not properly secured. The individuals that were on the scaffold on this told him after the fact that they reached over and they caused it to tip over because they were grabbing the plank that had just slipped from their hands that he had handed up to them.
What does that have to do with the plaintiff? What does that have to do with the plaintiff when the purpose of the law of 241 is to protect workers?
The purpose of the safety device, which is what the scaffold was supposed to be, is that it provides safety, but instead it ended up on top of the plaintiff. Doesn't seem pretty safe to me.
Well, Your Honor, the purpose of the scaffold is to provide a safe work platform for those using the scaffold.
So everybody on the ground, so what?
No, that's not what I'm saying, Your Honor. What I'm saying is there was nothing wrong with that scaffold. The individuals using it pulled it down or tipped it over when they jumped to one side to grab a
Counsel, we're
board.
there's an elephant in the room. It's called scaffolds are not supposed to tip over, scaffolds are not supposed to collapse, and when they do, people get hurt. Isn't that the simplest of equations? And when someone gets hurt, there is liability. Isn't that like 1, 2, 3, 4?
I disagree. The scaffold, there was nothing wrong with that scaffold. If 3 people go and push a scaffold over onto somebody else, now we're going to say that a
Does there have
scaffold
to be
has
anything
failed?
wrong with
I'm
the
sorry,
safety?
sir?
Does there have to be anything wrong with the safety device, or is it
has-
enough that the safety device simply doesn't provide adequate protection to a worker who is subjected to an elevation-related hazard?
If to a worker who's subjected to an elevated related risk, such as those on it, if it had collapsed because it wasn't put together properly, there was defects in the scaffold, and those painters who were charged with working above ground and needed that scaffold in order to do their work efficiently, yes, that would be a different circumstance. It's just not the facts that we
Tell
have
me what
here.
authority in the first department supports what you're saying.
Well, I have Court of Appeals, there's nothing to say that there's a defect in the scaffold. There's case law showing that plaintiff has to show that there was a failure in the safety mechanism.
Counsel, should we talk about the plank for a minute, that it was dropped on his head? I mean, should there have been some safety device to prevent that from happening?
Well, the plank putting up this scaffold, as I said, there's 15 component parts to it. He was handing up the last piece of it. There is no enumerated safety device under the statute that is necessary in order to pass up a plank or a piece of material to the painters on the scaffold. So the types of safety devices enumerated on the statute were not expected or reasonably anticipated to be used.
Would the safety device have been antithetical to the work they were performing in that moment?
Well, correct. I mean, they're trying to put together the actual scaffold, and what would they going to be using to hand up? It's akin to, he's the painter's helper. If he was handling up a roller on, say, had a 5-foot reach pole to give them a roller to use in the course of their work, and it slipped from the gentleman's hand as he handed it.
Between a roller and a plank. A plank that ends up on your head is kind of different from what do you call it, a painting?
Well, I'm saying if he had a roller or brush or any tools or materials that the helper is handing up to him, and it slips from their hand, it wasn't reasonably anticipated that that would happen, requiring a safety device enumerated under the statute.
Thank you, counsel.
All right, thank you.
I mean, that's tantamount to saying that while you're building a scaffold, you're not subject to the protections of Label Law 240, and this court has held time and again that you are. And most recently, I believe, Judge Moulton, you took part in this decision in Mejia versus 770 Broadway, where a scaffold pipe fell while a scaffold was being constructed, and it was unsecured, and it dropped, and it injured the plaintiff, and in that case, again, 240 was granted.
Did you make a prima facie showing that a violation of 240 sub 1 was a proximate cause of the injuries?
Yes, this is the testimony, and I'll quote it exactly, and this is what establishes prima facie a 240 violation. What I do know for a fact, that the huge wooden plank fell down in a vertical position, and it hit my head, then it hit other parts of my body, page 347. Page 530, the whole scaffold then fell down. And to the point of, was the scaffold on top of him, page 346, he ended up with all the scaffold, all the pieces of the scaffold on top of his body.
How do you respond to your friend's point that the scaffold was pushed, essentially, not intentionally, but for whatever reason was pushed by the coworkers, and that's what caused it to fall on or collapse onto the plaintiff, and not some inadequacy with the scaffold?
Sure. The Vergara case out of this court from, I believe, 2006 or 2008, I forget the exact year, but in that decision, this court said it doesn't matter what happened. In that case, a worker fell off of the scaffold, and the court said it doesn't matter whether the scaffold tipped, doesn't matter whether you walked off the edge, doesn't matter, you know, how the accident came to happen. It's enough that the scaffold was an inadequate device. And here, as I've heard questions being asked of my adversary, should a scaffold not stay erect? Should a scaffold not be capable of falling over? And that's, again, what establishes a 240 violation, the fact that it was capable of falling over. Thank you.
Thank you, Counselor.
Just quickly to draw a distinction in the Vergara case that counsel just cited, plaintiff walked off and fell off the scaffold while working at a height because it was missing side rails. In that instance, as I'm trying to put forth, is that scaffold was insufficient for the work to be performed because there was no side rails erected onto the scaffold to prevent him from falling off in the course of his work as he was working from an elevated height.
Thank you very much, Counsel. Thank you both.
Thank you, Your Honor.
The next case is BML Properties Limited versus China Construction, and Justice Scarpula is recused on this case.
May it please the court, I'm Maura Monahan from Debevoise and Plimpton on behalf of defendants appellants CSEC-B, a minority investor and the sole defendant that signed the investors agreement, CCA-B, the construction manager of the Baha Mar Resort, and CCA Inc., a distant U.S. affiliate with no role under the investors agreement or in construction, who's here only because of veil piercing. The trial court's decision should be reversed in its entirety. Make no mistake, there was no fraud and no breach. But recognizing that it's our job to make it easier for this court to reverse, I'd like to focus on two key legal errors in my argument here: misapplying fundamental principles of New York law that require reversal, damages, and veil piercing. First, damages. The trial court awarded plaintiff $830 million that it invested in 2011, even though the trial court decision identified all of the supposed misconduct as occurring in 2014.
It wasn't sufficient that they stayed the course? Even having invested that in 2011, they stayed the course during all the transactions that are at issue here?
No, Your Honor. It's quite clear that for fraud damages, the plaintiff would have to prove and the trial court would have to have found that the payments were made in reliance on the alleged fraudulent statements. Self-evidently, payments made in 2011 cannot have been made in reliance on 2014 and 2015 conduct or statements. In fact, the only case that the trial court cited at the end of the relevant paragraph, 161, was a fraud in the inducement case. The damages can't be awarded as breach of contract damages either, because as this court already recognized, the investors' agreement at issue contains an enforceable explicit waiver of consequential damages. These damages are quintessentially consequential, as this court already recognized in this very case, because as you will hear, they stem from amounts to be paid by third parties like hotel guests and brands.
But the theory is that this is, the plaintiff's theory, obviously, as you know, is just that this is what they invested and they want it back.
But Your Honor, that's the whole reason for consequential damages prohibitions in a contract. And this court has already been there and ruled that in this case, that provision was enforceable. Sophisticated parties represented by eminent counsel.
Counsel, wouldn't we have gone further, though, and saved everyone a lot of time and money? And said what you're posing that we meant to say?
Your Honor, I believe you did say that. So let me just read to you. This court didn't just say that the investors' agreement bars lost profits. It correctly held that Section 11.10 waives all damages that flow from business arrangements with third parties, holding, quote, the lost profits sought here are consequential in nature because they stem from collateral.
It's not lost profits.
Lost profits.
See, that's what I think we have a fundamental disagreement about that.
Well, so here's what I would say, Your Honor. Instead of but here is plaintiff's expert's testimony. The harm to plaintiff in the form of the loss of its shares occurred, quote, because it had no revenue coming in, close quote.
Well, the loss of the revenue caused the liquidity crisis, which in turn caused the financial collapse of the project, which in turn caused the loss of the contribution. Isn't that just direct damages, natural and probable consequence of the breach?
No, Your Honor. Natural and probable is a standard for causation. It is not the test for consequential damages. New York law
consequential would be extraordinary damages. Natural and probable, wouldn't that be the direct damages?
No, as Professor Williston, for example, has said, New York law describes consequential damages as those that flow from the consequences of the breach rather than from the breach itself. It's not that there has to be an absence of That's not accurate, Your Honor, because what happened was there was a slight delay in construction.
A slight delay?
Yes, a slight delay. So a
Delay and grounded in years for us in terms of a slight delay.
let me tell you, according to plaintiff's own CEO, the construction was very, very close. It was at
So give us just
the record
a span
site.
of years. I'm curious.
There is no span of years, there's a span of months. So they were aiming for a partial opening date of March 27th, 2015.
Date that they were aiming for came after multiple dates of non-completion, of not being able to open.
But Your Honor, those dates of non-completion before 2014 are not part of the case. And the reason they're not part of the case is because they stemmed from plaintiff's own conduct. They were the result of plaintiff not getting its architect drawings done because it fired the architect and started over. The case is all about what happened after 2014 and 2015. In addition, this court
You mean when the
already...
workers were sent back to China?
I'm sorry?
You mean when the workers were sent back?
That's another misconception. There's no evidence that workers were sent back to China.
Well, didn't they go back for the Chinese New Year? About approximately 300 of them, right at the cusp of when the project was almost complete, just near completion.
So, Your Honor, none of that has any bearing on the
No, but isn't the answer yes?
The answer is those were workers whose contracts had come to an end.
Were they replaced?
But it's still yes, right? It's
Yes,
still that they
the
were sent, they
total-
went back to China, right? And they weren't available to work on the project
The
right at the
total-
cusp of when the project was set to be complete, to use your words.
The total number of workers increased. It didn't decrease. The net number of workers increased.
Oh, it did?
Yes, those workers were
Is
permitted.
that in the record, counsel, that it increased? Because I didn't see it.
My colleague is grabbing the site.
Okay, that sounds good.
Well, I mean, you can tell us how they increased, right? And you don't
They
have to find.
hired, so they had agreed to bring in 200 new Chinese workers. They brought in over 340. They hired a whole bunch of local workers, increasing the total number of workers on the project to numbers that were thousands over what had been agreed upon in the original contract. But all of that doesn't
And
change the
What
fact.
you're saying was borne out by the trial testimony?
Yes, Your Honor.
Okay.
So CCAB increased its total workforce on net by over 1,000 workers, peaking at over 6,000 in February of 2015. That's in the record at 5283, 7425, and 7254. In addition, we can't lose sight of the fact that this court already found that plaintiff acted wrongfully, violated the investors agreement when it filed for Chapter 11. This court already determined that in its decision last year. It was only after that, according to plaintiff's own damages expert, that it lost the value of the shares.
So, counsel, I feel like we're going in a nonlinear movement. So let me try to focus a little bit. Bahamar agreed to release $54 million to the defendants. That money was supposedly for continued improvement so that this resort could open. But that money was instead spent to purchase a property, a Hilton property nearby. Can you explain that?
Yes, Your Honor.
Can you explain how that's not a diversion?
Well, for one thing, the $54 million, what the trial court relied on to say that that was supposed to be used to pay future contractors was a litigation response to interrogatories made years later. So self-evidently, the payment wasn't made in response to interrogatory responses in litigation. What the trial court actually found was that...
Didn't the trial court rely on testimony from witnesses regarding what that $54 million was meant to go to? And wasn't that meant to go to subcontractors who had not been paid so that the project can continue going forward?
So the trial court relied on, the trial court itself found that this was a commercial settlement of a dispute over $98 million in construction change directive payments that were already due at that point. That's in the record at page 35 and in the record at 5275. And again, plaintiff admits that $54 million has nothing to do with the $830 million. That $54 million is paid after the supposed conduct that you are concerned with. So it is different than the $830 million, which is what I'm talking about.
It's not the damages, but isn't it reflective of a breach of the best interest clause, section 4.7?
Section 4.7 contains no reference to a construction timeline or resources. It is just about
That's not what the question was. The question was, does it relate to doing what is in the best interest of the project?
Yes, Your
And
Honor.
it says at all times. It doesn't say in the best interest of the investment or in the best interest of construction. It says in the best interest of the project at all times.
Yes, Your Honor, it does say that. It is related to the role of a single individual, a director who is on the board of directors, Mr. Wu. That's the only individual at issue. You will have noticed that the three entities are corporate entities. CCAB is a company. It's a construction manager. It has a construction contract, and the construction contract caps damages at $50 million for construction delay. This $845 million award is completely non-commensurate with that. I'd like to
That also raises the, which we should probably talk about on your rebuttal time, about Justice Borok's piercing the corporate veil. So we should talk about that. But
correct, Your Honor. Can I have 1 second now, or I'll do it on rebuttal if you prefer?
Yeah, on rebuttal, please. Thank you.
May it please the court, my name is Jacob Bookdahl. I'm with Sussman Godfrey, and with Mark Zotterer, we represent the respondent, the plaintiff, BMLP. Why don't I start with veil piercing, because the court's interested in it. This was a situation where not only did the defendant fail to plead a different law, not only did they fail to give notice of the different law, but they, in fact, in their prior submissions to this very court, acknowledged that New York law would govern the veil piercing question. If you look back just a brief they followed a year ago on March 8th of 2024.
The first statement of Bahamian law by your opponents was post-trial, right?
It was post-trial. That they had brought up the question of which law might apply in a letter pre-trial, but they didn't actually put any meat on the bones.
No, and one can imagine, a trial court needing to know that information ahead of time so that it knows how to manage the trial.
Not only that, Your Honor, we would have put on a different case if different law applied. And like I said, they had acknowledged that New York law was going to govern this question. Footnote 10 of that reply brief they filed in this court cites a First Department Appellate Division case on the New York standard for veil piercing, which is the standard that we met in spades.
What direct evidence did you put before the trial court regarding veil piercing?
Between veil piercing, we proved the utter domination and control by CCA of its two other companies, in particular, Ning Wan, who was the senior most executive of CCA. The testimony by all of his subordinates was that he was the ultimate decision maker on behalf of all three of the defendants.
He was also the first board member, right?
He was the initial board member, and he only was replaced as the board member when he instructed Mr. Wu to take his position. Mr. Wu then, at which point, said that he took that position at the direction of Mr. Wan, not even knowing that there was a best efforts obligation in the contract, and therefore that was why the trial court made the finding that that was the start of the breach of that obligation, because the board member was not even aware of it at the time that he assumed that board seat. As far as a couple of things about the record.
A quick question regarding liquidity. Were you not in a liquidity crisis well before the project failed? How do you respond to that?
The short answer is no. There was no liquidity crisis until shortly before the failure. And what the evidence showed is that the first thing that started to cause the liquidity crisis was the release of the $54 million, which the evidence showed that it was expressly represented to our client that that money would be used to pay subcontractors, that they needed that money to pay subcontractors, and instead, as the court alluded to, it was diverted to buy the Hilton
What about
Hotel.
the argument that you were required to sell condominiums in order to raise some funds, and only 20 condominiums were sold, and that in part caused the liquidity crisis?
Your Honor, that is not what the evidence showed at trial. What the evidence showed at trial, and I'll direct the court's attention to paragraph 137, where the trial court said that Mr. Ismailian, he was the chief executive of our client, he credibly testified that if he had known the project would not have opened on March 27, 2015, and of course he didn't know that, not only because he was lied to about it, but all of the obstacles to that opening date were being concealed from him, quote, BML would have conserved its cash and would not have entered into the liquidity crisis that ultimately led to the liquidation. And the court found that Mr. Ismailian testified credibly that there was a lot of spending that happened in reliance on the false statements that the resort would open on time. First of all, it was publicly announced. Second of all, they spent millions of dollars to train staff for that expected opening. They spent millions of dollars on marketing. They flew in cash to open the casino. They incurred all of these costs in those early months of 2015 that they would have otherwise not have spent, and that is what caused the liquidity crisis.
Your adversary in their brief made arguments that there were certain things that your client was required to do regarding the casino that it did not do, which would have made opening impossible in any event.
The court rejected that argument based on the testimony of witnesses at trial, and in particular, Mr. Dunlap and Mr. Ismailian both explained to the court and credibly testified that the point was that they needed to have sufficient facilities open in order to have paying guests. It was always understood that it wouldn't be fully open. The casino issue, they had the license, they would have been able to open the casino, and the court understood that. And the real issue is just, would there be an extra boutique? Would there be an extra retail outlet? Some of the things would not have been open, but they would have been able to have guests in on time. And to go back to your
there's
initial...
that best efforts language, which is always undermining someone in your position. But in this case, you limit that. You say it was only regarding certain scheduling milestones. Is that correct?
So the best efforts obligation...
That would imply that the March 27 date was not hard.
Right. So two things. First of all, there's the best efforts obligation in the contract, which was, I'm sorry, I'm confusing two things. So first of all, had to act at all times in the best interests of the project. That's one obligation in the contract.
Yeah, I'm talking about best efforts.
Best efforts.
Sorry if I said best interests. I'm sorry.
I think I misheard you, and
Okay.
I apologize. So what defendants tried to do is they tried to use the words best efforts, which were listed in one of the paragraphs of the November meeting minutes from 2014, and they tried to take that reference to best efforts and say that the entire issue of the date was only a best efforts obligation. But what the court pointed out was that over and over, the defendants, led by Ning Yuan of CCA, promised explicitly over and over again, we understand that's a hard date, we will meet that date. It wasn't just in November of 2014. There was an additional board meeting in the Bahamas in December of 2014. There were additional communications in early 2015. And each time the defendants reiterated, we get it, we understand, we know you have to open. And specifically, Tiger Wu, who was one of the board members, joined the rest of the board in authorizing the public announcement of the resort in March of 2015. And
you wouldn't have announced it publicly if you weren't going to open, because that would cause issues, right?
Well, of course, Your Honor, beginning with the fact that you have to start taking reservations. You can't take reservations and then say, I'm sorry, we made our best efforts. Why don't you come back in a couple of weeks after people fly to Nassau and the Bahamas?
Counsel, would you briefly address the issue of damages, the correct measure of damages?
Right. So we presented the trial court back at summary judgment with two damages models. One was a lost profits model, which this court rejected a year ago. The second one was the one that we presented at trial after they didn't challenge it, and then we put it forward at trial, which was simply that our client had invested and contributed a total of $845 million to the project. It was $745 million in land and licenses and other kind of valuable pieces of property that were contributed, and $100 million in cash.
If I understood your friend correctly before I cut her off, your expert, you may have characterized these as direct damages, but based on your expert's opinion, they were really consequential damages in direct damages clothing.
I believe what my friend was doing was quoting from that portion of our expert's damages model that related to his lost profits model, which we didn't present, because the trial court, in response to this court's order, very carefully policed that issue and did not let either side talk about the future profitability of the resort. We would be here with a larger judgment, respectfully, if we had been allowed to put that lost profits model in. We didn't agree with the court's ruling. We abided by it, and that's why the damages model we presented was very simple. It was, here's what we put in, And every fraud case says that a plaintiff is supposed to be put back in the position that it would otherwise be prior to the commission of the fraud. And that's all we're asking to do. Give us back what we contributed. That was $845 million. That number was agreed to. There was an
It's in
accounting.
the investors' agreement. I don't think you need to belabor that point. Thank you very much, counsel.
Thank you.
Thank you, Your Honors. Starting with a few things that were raised by my adversary, and then I'll turn to veil piercing. I was not relying on the lost profits portion of the damages expert's report. What I was doing was quoting trial testimony by plaintiff's expert. I will add another quote from plaintiff's expert, which is that plaintiff's damages expert projected that even if Baha Mar opened as planned on March 27th, BML would have consistently operated at a loss, leaving no money for loan repayment, which would cause a default. That's in the record at 4011, 4019, and 11378 to 11379.
And further loans were impossible because of the terms of the initial loan, correct?
I'm sorry, Your Honor?
The equity to whatever, the Chinese
Correct, the
loan
debt to
said no more loans because you'd be violating the terms of our loan.
Well, they violated the terms of the loan in several ways, including by filing for Chapter 11 without the consent of either the minority investor or the lender. After that, there were discussions about a potential out-of-court restructuring, but Mr. Ismerlian declined to give the guarantee, and so those discussions fell apart. I would also note that plaintiff's expert was crystal clear, this is his trial testimony, this is not based on lost profits, that anything that happens, this is a quote, anything that happens after that in the bankruptcy process, however it worked, that ultimately caused plaintiff to lose its ownership interest, that's why this is 0 in this column. That's in the record at 1617 to 1619. So plaintiff's expert's own testimony was that there was a breach, there was a consequence of that breach, which was the filing of a bankruptcy, which this court already held was a wrongful act by plaintiff, and only after that did the share value decline to 0. Turning to veil piercing, it is not the case that there was any failure to comply with CPLR 4511. Bahamian law applied to this question. It was presented—
When was that raised for the trial court?
It was presented in joint questions pre-trial that were submitted to the trial court.
When was the assertion by your clients raised that Bahamian law applied?
So the joint questions were
I
submitted—
wasn't asking about the joint question. I was asking about the assertion that Bahamian law applied to that question.
That was when it was asserted, Your Honor. So in the joint questions, which are in the record at 765 to 768, then there was a motion for a directed verdict, which is in the record at 2498.
Directed verdict, so that meant post-trial, right? After the trial?
No, it was during the trial. So it was after the submission of plaintiff's evidence. It was a motion—
The first time you raised the application of Bahamian law?
No, we had raised it in the joint questions that were submitted pre-trial. So we raised it pre-trial—
How many days before
during
trial?
trial,
How many—
post-trial.
Counsel,
I'm going to blank. The court had held
that's eve of trial, right?
like a month before, a couple weeks before, something like that, before a conference. And then we put in a declaration with our post-trial brief, to which plaintiff had a full opportunity to respond.
I know, but you
And-
understand the point that I asked the other side, which is just, like you're setting up the architecture of this trial. You want to know what law applies to this very important point before you commence the trial. And I mean, just
That's why
thinking-
we included it in the joint questions before trial.
What
You've been
guidance-
through so much
more than that.
litigation with this case, and you mean to say that if something that is so critical to the case, which is what law applies, that you do that on the eve of trial in a questionnaire?
It wasn't a questionnaire. It was like a pleading that was filed with the court that identified the questions to be presented. I would also note, Your Honors, though, just so it's clear, that it's our position that even under New York law, veil piercing would be improper. Everything that plaintiff is talking about relates to this argument that there's domination. They've made no showing, none, that the corporate form itself was used to perpetrate a fraud. Justice Higgett, you've repeatedly emphasized the necessity of that finding in cases like Dragons 516 Limited, which you decided in 2024. There's no question but that this sophisticated party knew it was signing a contract with CSEC-B and that construction was managed by CCAB, and there's no evidence and no trial court finding to the contrary. It's also the case, and this is in another case of Justice Higgett's, GNY Maintenance Corp. At 215 AD 3rd 553, that using one's domination and control to cause another to breach contract obligations is insufficient to pierce the corporate veil. That's what plaintiff is arguing, and that's insufficient even under New York law.
Thank you very much, counsel. Both sides, your briefs are excellent, and we thank you very much for your
Thank you,
presentation.
Your Honor.
Thank you. The next case is Goldstein versus Berenbaum. Please.
Good afternoon, Your Honors. May it please the Court, my name is Jacqueline Mandel. I represent Dr. Berenbaum and Manhattan Sports Therapy on this appeal. Our position here is that the defendant's motion for summary judgment should have been granted because the plaintiff's proof in opposition was legally insufficient to raise a triable issue of fact. The primary thrust of our argument rests on the well-established principle of law that in order to raise a triable issue of fact in a medical malpractice action, the plaintiff's expert must address and refute the key specific factual assertions made by the defendant's experts, and that didn't happen here. So I know the court knows this is a claim that treatment caused traumatically induced bilateral vertebral artery dissections. Our experts, in support of our prima facie showing.
Would you take, do you take any issue with the fact that Dr. Harrell opined that the plaintiff did not have a pre-existing condition?
I know that's what he testified.
Or an
I know that
underlying
was his
undiagnosed condition, however you want to put it?
Yes.
Okay. And that also that, I mean, he did say outright that the Dr. Berenbaum's manipulations did cause the VADs. So what else are we supposed to do?
So, Your Honor, he said, I have his expert affirmation here, of course. He said that this kind of treatment can cause dissections and a stroke, and we don't dispute that. What we dispute is, and our position is, although it can happen, here it didn't happen.
What about the treating doctors who indicate that from looking at the MRIs that it did in fact happen?
So a couple of things about that, Your Honor. Number one, that's only in plaintiff's counsel's brief. That is nowhere in the plaintiff's expert's affirmation. He does not rely on what the treating doctors had to say. You can look through the 5 pages of his affirmation. You will not find it. And just having plaintiff's counsel cite some notations in medical records is insufficient.
No, those medical records are evidence, right? So,
It does
so
seem
what
germane to
if
treatment,
if the expert testifies to it or not? Those are evidence that the plaintiff put in, right? They're medical records, and the treating doctors in those medical records stated that the chiropractic treatment was what caused the VADs, right?
2 things. I disagree with you, Your Honor. First of all that those medical records say is that the dissections happened in the setting of. It's just information that they had. It's just information that they had about the plaintiff's treatment history. But, Your Honor, it's black letter law in New York. I mean, this is not a contestable fact that in a malpractice action, the plaintiff has to submit competent expert proof in admissible form in order to raise a triable issue.
And couldn't competent expert proof be the records of the treating doctor?
No, Your Honor. No, they actually couldn't be. If that was the case, what's the point of having an expert affirmation?
No, because you want to bolster your case. I have seen plenty of cases where the treating doctor gets up on the stand and says,
You
"This
could
is what caused that."
you could bolster your case if your expert says it, but you can't have an expert not say it
No,
and
no,
just
you're
use
telling
medical
me that
records.
a plaintiff can't rely on their treating doctor's opinion.
I'm not saying that, Your
That's
Honor.
literally what you just said. But okay, let's move on.
Okay, so
Well, why don't we just go back to the experts' affidavit, since you are heavily relying on that? Doesn't it raise a question of fact with regard to the reliance on the peer-reviewed medical literature that the VADs could be associated with the chiropractic maneuver?
Your Honor, we're not disputing that chiropractic manipulation can be associated with this injury. Our point, and what our experts explained in detail, is that even though it can, here it didn't. And how did we prove
Doesn't
that?
the jury have to figure that out, counsel?
They would if the plaintiff raised an issue of
I mean,
fact.
when I looked at the record, I said, well, this is, one expert says that the plaintiff sustained a traumatic injury. The other one says it was a spontaneous injury. One says it had to manifest itself right away when the manipulation took place. The other one says it could, according to peer-reviewed literature, the manifestation can take place within the course of 30 days. So given that dichotomy, and given the fact that you have a procedure where the plaintiff is lying on his back in a chair, his head dangled over the edge of the chair to rest on the chiropractor's lap, and first she uses a towel, and then she uses her hands in what is described as very aggressive type movements. She herself says high velocity, low amplitude action, fast but soft, with extension and rotation. It sounds like a very risky and very potentially dangerous situation unless it's done correctly, assuming that it can be done correctly. Isn't this what typically falls within the realm of a jury to decide, as opposed to us to decide or a trial court to decide, motion court, on paper?
May I?
Please.
Okay. I'm going to start by just saying no. That is not. It is not enough in our case, in our position, from our perspective. It's not nearly enough. What our experts did in this case was, first of all, explain in detail that there are two different kinds of dissections. There's spontaneous, there's traumatic. The plaintiff's expert didn't even address that there are different kinds. He just said, in conclusory, declaratory statement, I think this was traumatic. That's number one. Then our experts also went through the process of providing the court with the hallmark characteristics that would be found if somebody had a traumatic dissection. The first one of those was immediate and severe pain. Plaintiff's expert, you will not find the word pain or any synonym for the word pain in the plaintiff's expert's affirmation. It's not there. On top of that, you have Mr. Goldstein's own sworn testimony that not only did he not experience immediate or severe pain, he said maybe a little discomfort. He said, and the only reason I thought it was maybe a little uncomfortable is because it's not the way someone typically moves their neck.
He had headaches.
That is nothing he had headaches before he got there, is the evidence. That those are not connected. But he also didn't have immediate and severe pain. And then he testified that this treatment that was given actually relieved his pain.
Counsel, let me ask you, may I interrupt you because your red light's on? I just
know.
have one quick question for you. Doesn't the plaintiff's expert's statement that this can happen within 30 days of, or a period of time after the manipulation, a fortiori dispute your if it happens 30 days later, you can't have immediate pain, can you? Right? So it doesn't. So doesn't that raise an issue of fact?
No. May I?
Please.
May I answer your question? First of all, he's not talking about pain in his expert opinion. It's not in here. The most that he's talking about there, and he's not even really talking about it there, is the amount of time until you would see it on imaging. It is an incontested fact. I urge you to read his expert affidavit word for word and compare it to my experts. You will not find this issue of immediate severe pain, the hallmark characteristic of a traumatic dissection. You will not find it in this expert affidavit. You will not find the expert actually discussing what this peer-reviewed literature that all he does is cite what any of it says. He doesn't refute. My experts say in their affirmations that trauma, in a traumatically induced dissection, the arterial damage happens immediately at the time of the trauma. So how does this stay invisible? How does this man stay symptom-free if it happened traumatically?
You make that point very well in your brief. You'll have
Thank you,
time in
Your Honor.
rebuttal.
Good afternoon, Your Honors. May it please the court, Sarah Mahoney on behalf of the plaintiff respondent.
Counsel, can you address the issue of pain, the lack of any pain at the time of the...
Yes, Your Honor. So,
And does your expert talk about that at all?
so Mr. Goldstein did testify that he had constant headaches after the time of the first neck manipulation that she did on November 21st, continuing through the time of the onset of his stroke symptoms less than 5 days later.
Did the
He had a
headaches,
constant headache throughout.
did the headaches occur before the treatment?
No, Your Honor. He said that constant headache started as a result of that treatment, that first treatment where the neck manipulations occurred. So he did have constant headache afterwards that, again, continued through the onset of the stroke symptoms. Additionally, pain is subjective. And further, as the court has already noted, his treating physicians...
Right, but what I'm specifically asking is, did your expert address the defendant's expert statement that you could not have had a spontaneous VAD or VAD, I guess, without excruciating pain right at that moment?
Your Honor, what our expert does is consider all the factors.
So he didn't specifically address that.
I don't think he uses the word pain, no, but he says that in conjunction with all the factors, including the description, Mr. Goldstein's description of what she did to his neck, which, by the way, is entirely consistent with Barenbaum's own definition of what a cervical manipulation is. She testified that it's quick rotation from side to side, and that's exactly what he said happened here. And she admits, consistent with the literature that the defendants ignore, that yes, that kind of cervical manipulation in the context of a chiropractic manipulation like this does have a significant association with bilateral vertebral artery dissection and stroke.
Go ahead.
But it's the temporal component that I think we're concerned with. So the defendant's experts say if the VAD occurs, there's going to be immediate excruciating pain. That's the telltale symptom. And the bilateral dissections occur immediately. Does your expert deal with that, what I'll call temporal piece of does Dr. Harold address that temporal piece of the defendant's expert's presentation?
Well, in his affidavit, he does say that he considers temporality. He uses the word temporality in his affidavit as a factor among many that he considers. So the onset of these symptoms was less than 5 days from the last cervical manipulation. And he says that Mr. Goldstein, a young, healthy 34-year-old man, had no underlying predisposition to these bilateral vertebral artery dissections. So considering that, and consistent with his treating physicians, who also looked at all the imaging, knew all the circumstances, also found that this happened because of the chiropractic manipulations, those are all factors that raise issues of fact here.
And consistent with the peer review articles that the onset could be within 30 days, right?
Yes, absolutely.
Would you address the issue of informed consent? To the extent that the MRIs prior to the first manipulation showed that he had had a stroke, am I right? It was...
No, he had no prior history of stroke.
He had no prior strokes before this?
Correct. The first stroke symptoms started less than 5 days after the last manipulation.
I thought that the MRI showed something before then. Am I wrong?
Their experts claim that the MRI showed some sort of underlying, never diagnosed arteriopathy, but our expert says that is not true, consistent with what those reports at the time said.
So the plaintiff was never treated previously for stroke?
For stroke, correct. He did have a treating neurologist prior to this, Dr. Sun, who also, after all this, in his own notes said, yes, I believe that these strokes occurred due to chiropractic manipulations, but no, he wasn't treating with Dr. Sun prior to this for stroke symptoms.
My question.
Yes, yes. And in terms of informed consent, it's undisputed that Berenbaum did not obtain
Dr. Birnbaum?
Dr. Berenbaum did not obtain Mr. Goldstein's consent, informed consent in terms of informing him of any risk of vertebral artery dissections and resulting stroke. She acknowledged that, again, consistent with literature that the defendants ignore, she acknowledged that, yes, this is a known risk. This is something that we know in the medical community, something we learn in chiropractic school, and yet she did not inform him.
If there was no prior history of stroke, did she still have an obligation to inform him of the risk of stroke?
Yes, Your Honor, yes. And our expert specifically cites in his affidavit, in a footnote, he cites a statement from it says, cervical arterial dissections and association with cervical manipulative therapy, a statement for healthcare professionals.
You know you're talking too fast, right?
Sorry, from the American Heart Association, American Stroke Association, that specifically says, quote, patients should be informed of the statistical association between cervical dissection and cervical manipulation therapy prior to undergoing manipulation of the cervical spine. So our expert does specifically cite that in his affidavit.
Does this apply to chiropractic treatment?
Yes, Your Honor, yes. I want to make just one other point. Counsel said that his treating physicians documented that these cervical dissections occurred in the setting of the cervical manipulations. That's not true. His treating physicians actually specifically said that they believed that the strokes were caused by these cervical manipulations.
Let me just ask you, does your expert say that this type of treatment could cause delayed pain?
No, I don't believe he says that specifically. Again, we still have issues of fact here because considering all the factors that we have, Berenbaum's own testimony.
Well, okay,
Mr.
but let me
Goldstein's-
just say, if the defendant's doctor is saying it has to have pain right then and there, if your doctor doesn't address that, let me ask you a different question. How does your doctor address that? How does your expert, I should say, address that?
Well, again, I think he considers all the factors, all the testimony, the temporality, and he says, based on this in the medical literature, that there's no other medical explanation here for Mr. Goldstein's random, otherwise random strokes, which they're claiming they're just totally random, spontaneous strokes. But there's no other medical explanation here. So considering that, the medical literature, Mr. Goldstein's own testimony, Berenbaum's own testimony, and all of that is consistent with what his multiple treating physicians at the time deemed to be the cause of these strokes, that all raises an issue of fact.
Please.
Is there anything in the record that says that pain is a precursor to stroke? That it is a symptom that is absolutely associated with as a stroke warning? I'm saying it wrong, but is pain an indicator of stroke?
Your Honor, there's nothing.
Does anybody say that?
No, not that specifically. Defendants' experts say, again, that pain is associated with these bilateral vertebral artery dissections. However, again, Mr. Goldstein did say they were uncomfortable. He did say they caused him constant headache right after the first manipulation, continuing through to the onset of stroke symptoms. And again, pain is subjective. So, there's so many other issues of fact here that preclude summary judgment for the defendants.
Thank you, counsel.
Thank you.
I feel like I'm looking at a different expert affirmation than everybody else.
Are you scolding us?
No, I'm just feeling a little mystified. It's not scolding. I would never, I would never do that. I'm feeling a little alternate universe. I'm looking at pages 1170 through 1175 of the record. The plaintiff's expert's opinion doesn't even start until 1172, where we get these declarative sentences that stand for the unremarkable, undisputed proposition that cervical manipulation can cause this injury. Okay, so what? We're not disputing that. And then you don't get to opinion, which I'm putting in air quotes, until page 1173, paragraph 14, where all that he says, he being Dr. Harrell, is that there must be causation here because of the timing. He says the temporality of the treatment administered to Mr. Goldstein by Dr. Berenbaum, with the last treatment on November 27, and symptoms on December 2, establishes a clear correlation between the traction and the manipulation and the fact that he had dissection. So
Well, didn't he also look at the plaintiff's medical records? It's not
no, no, Your Honor, I mean, that's kind of like my alternate universe feeling. It's not in here. I've read it and I've reread it and I've read it again. I read it while the plaintiff was arguing. It's not in here. And so his whole thing, I mean, flies in the face of this court's decisions over and over again on hindsight reasoning that the fact of the injury itself cannot be used as the basis for a finding of malpractice, number one. And number two, he doesn't even talk about, my experts go to huge lengths to talk about what's in and what's not in the imaging studies. There's not a word about what is and what isn't in the imaging studies here. So where my experts are telling you what you would have to find in a traumatic dissection about injuries, to not just the dissections themselves, but in bilateral dissections that you'd have to see on the imaging, damage, collateral damage to structures and tissues adjacent to and in between the vertebral arteries, that's not addressed here either. He doesn't tell you anything about what the imaging studies show. And so just to rely on, well, the doctors who saw him subsequently said that...
So he must have reviewed the medical records. You're not saying that he didn't. I thought you said he didn't review the medical records. He is relying on...
talk about them.
Okay, but he reviewed the medical records where there was no... And the doctors, the treatment records, and the medical literature, correct?
Your Honor, he says in his affirmation, I've reviewed the medical records, the images, and the deposition testimony, and then he proceeds not to talk about any of it. He doesn't discuss what the subsequent treating doctors say. He doesn't discuss what the images show, the December 2, the December 5, that MRA that's done on December 5, which is done specifically to look at blood vessels, which is totally normal. No explanation for that. Doesn't counter that my experts say, you have to see it, it has to be there. Doesn't talk about it. Cites a bunch of medical literature, doesn't tell you what it says. If that's not a conclusory expert opinion, I don't know how. Judge Moulton, Cabrera, in August of 2024, Judge Scarpula in, hold on.
It's okay, counsel. We're at the end of the...
These are your decisions. I have one from at least each of you, not from everybody, that stands for the principle, the again, unremarkable, well-founded principle that in order to raise an issue of fact, the plaintiff's expert has to address all these specific assertions. And I'm submitting to you that when you read these 5 pages, you are not going to find addressing, much less refutation, on all the different reasons that my doctors explained to this court and to the court below.
Thank you, counsel. You do unpack it very well in your briefs, this
Thank you,
argument.
Your Honor.
Thank you very much. Thank you both. Okay, the next case is Atta versus 450 West. Please.
May it please the court. My name is Peter Zlotnick from Saul Ewing on behalf of the ATA appellants. This case is before you today on an appeal from a decision and order from Justice Robert Reed that was decided during oral argument on December 20th, 2023, and was memorialized in a short form order on December 21st, 2023. At the heart of this appeal is that the verified amended petition, which is an Article 78 petition, is replete with extensive allegations that...
So let's talk about the House rules, perhaps, begin there.
Yes, Your Honor.
Because, of course, they're subject to business judgment review. It seems to me your strongest case is House Rule 21, because it does seem to single out your client. You want to talk about that?
Yes, Your Honor. It is clear from both Lewandowski and Pullman and their progeny that in order for a House rule to be promulgated properly under the business judgment rule, it has to have a legitimate corporate purpose, it cannot discriminate against any shareholder, and it has to be done in good faith. And we have provided extensive evidence, including 10 affidavits at the court below, extensive pleadings in our papers, that the House rules in this particular case were set forth to discriminate, to retaliate, and to try to force...
Counsel, the House rules apply to all of the tenants of this location, correct?
The House rules in general are supposed to apply to all tenants in this location, but this is a unique property, Your Honor, and this particular House rule, Rule 21, was specifically designated to apply to my client. It couldn't apply to any other shareholder or lessee in the building because my client has possession...
So, counsel, let's talk about the Second Amendment to the offering plan.
Yes, Your Honor.
In the description of the Second Amendment, it says, upon closing of title with the cooperative corporation, the following contracts will exist and be binding upon the cooperative corporation. And it says, I don't even know how to read this. Let's just say record 900. That's the easiest way. The boiler room shall, in addition to the square footage set forth herein, include that portion of the parking lot for a distance of approximately 25 feet extending from the boiler building. And we know that the boiler room became unit 1B, and the plaintiff purchased 1A and 1B, which included the parking lot within its demise premises, within the demise premises. So in looking at a diagram of the floor plan, you can see that the parking lot is described within the floor plan as an accessory parking area. My question to you is, was there an amendment to the offering plan at any point that changed the use of the parking area? Was there any money offered to change the use of the parking area? Is this a taking?
The answer to your question, Honor, is yes, there was a change, but if I may, I'll give you some history so that Your Honor and Your Honors can understand how this amendment, Amendment 2, came into being and why our client has acceded to the space that's exterior to the boiler room itself, the loading area, the 4 parking spaces, and even the right-of-way that I'm sure Your Honor will get to. The original sponsor of this building purchased, and there is an affidavit that was submitted.
I'm asking you whether the use of what is designated in the Second Amendment and in the floor plan and in the certificate of occupancy, whether the use of the parking lot can be changed by a House rule or whether that requires a different process, such as a purchase.
It requires an amendment to the bylaws and the proprietary lease, Your Honor, that is adopted by 66 2/3% of the shareholders. And so to the extent that the board might try by executive fiat to change or confiscate certain portions of a shareholder or proprietary lessee's space, that's expressly prohibited under all of the case law that I've cited earlier, that's in our briefs, but also under the existing governing documents. And Your Honor, the original owner of the space that Ada Inc. and Miss Ada acquired was the original sponsor. And in fact, the original sponsor had every interest. This is a landlocked space.
Right.
And so there is no way to get to our clients.
Right, which is a different issue, which is the easement of necessity.
But the use itself, the zoning, was always the same. It was always for artistic purposes and manufacturing. In fact, if you look at the certificate of occupancy in the record, it specifically designates 1A and 1B as an artistic use, but it's been changed over time. So to that extent, the purpose, the specified purpose, is contained in the CO, and it's always remained manufacturing or for industrial use.
Thank you, counsel. You have time in rebuttal.
Thank you.
Good afternoon, Your Honors. David Ross from Morris & Cohen for Jeff Green and AAC Realty. In this case, for my clients, the judge dismissed with prejudice my clients' claims, which are somewhat different. They relate to different House rules, Rule 27 in particular. And we allege in pretty voluminous form that it was done in retaliation for certain acts. And it was done because Mr. Melkonian, who is the board's president, wanted to basically convert the building to residential use and basically bought 3 units and was trying to get my clients out on the cheap. And that's what he was trying to do. And in doing so, there was a lease in place where my client had leased.
Counsel, does Rule 27 apply to all of the tenants?
It does apply to all the tenants, but cleverly, like any kind of scheme, it was done with my clients in mind, to target my clients. When you think of it from a perspective of my client alleged, and again, this is a motion to dismiss without any discovery, my client alleged that they were being retaliated against because the board did not want these kind of units in the building anymore. And
do we have any evidence or any allegations or pleadings that the rule was enacted for anything other than a legitimate purpose?
Yes, we have the actions, we have the ulterior actions of the board. For example, there was no issue with the elevator at any time, right? The freight elevator that was being used, they knew was being used for photo shoots and had to be used multiple times per day. A couple of years before this board came in, that freight elevator was automated at a cost to all the shareholders for secure purposes so it could be used properly. And what they enacted was every time, over 1 time a day, to use a freight elevator, $65 for each trip up the elevator. Another $65 down the elevator.
But right, don't forget that our scope of review in this, I mean, this is a corporation, right? You have to allege a lot to get over business judgment particularly in a House rule that applies to every single one. What factual basis have you alleged that was not a legitimate rule for the entire condo, or I guess it's condo association?
Well, because the freight elevator was mostly exclusively used by my client for these purposes multiple times a day. They knew that. The passenger elevator, which is used by other units in the building, there's no tax on that. There's no payment on that. It was used, so they knew it would affect my clients disparately. And Your Honor, you were part of the Tahari case where you also ruled and also reversed a motion to dismiss where basically similar allegations of disparate treatment were pled in that case. And again, that was pre-discovery.
No, but it was specific disparate treatment. This applies to everyone. Just because your client happens to use it more doesn't make it disparate treatment.
Well,
it might be a disparate effect because of your client's excessive use, but it's not targeted to your client.
Your Honor, it is targeted to your client because they knew, again, the allegations are, and these are unrebutted allegations, that they wanted to rid my client of the photo studios. And Your Honor, the other piece too, after we went to court and an injunction was denied. The day after, a member of the board called my client saying, hey, you want to sell your unit now? I mean, again, this is evidence that they were trying to get them out. No one would say that.
Had
the
that,
next day.
that was Mr. Swainpool, right? The person.
That's Mr. Swainpool, correct.
Had he expressed an interest in buying Mr. Green's space prior to that?
And that's not in the record, Your Honor, not that I'm aware of.
All right, counsel, you have time in rebuttal as well.
Thank you.
Thank you.
Good afternoon, Your Honors. Jeffrey Metz for the for the co-op. Your Honors, the business judgment rule applies here, and it really limits your review. As Judge Scarpula said, there is a very high hill to climb here because the House rules affect everybody here. Now, let's talk about Ms.
Except 21 only applies to one.
Well-
So that automatically, we're looking at it because it applies, 1 second, may I just finish? It applies to only one tenant, right?
Only one tenant who had no right to use the space for parking to begin with. Now, let's,
Since when?
well, right from the beginning.
Do not point at me, please, when you talk.
I'm sorry, Judge?
Do not point at
I'm
me
sorry,
when you
Judge.
talk. Thank you so
Your
much.
Honor,
So, counsel, the Second Amendment says that the space is a space that includes parking.
No, okay. May I respond?
Please.
Go away.
Okay, first, let's look at page 729 of the record. It's the speculative risks in the offering plan, which Ms. Otter reviewed before she purchased. It says there are no parking spaces available for tenant shareholders.
We read that, but it also does not say, it doesn't prohibit parking spaces, does it?
It does not. Second, Your Honor, second is that you've got the 2011 amendments that Ms. Otter was on the board at the time, and all the proprietary leases were amended to say that the co-op could regulate the use of the space, of the building.
Yeah, but that's not specific enough. So there's no way as a matter of law you can say one way or another on that issue. You just can't, whether.
But Judge?
Yes.
Judge, let me push back a drop. Because there is nothing in the Second Amendment that grants her the right for parking. What the Second Amendment does is define the space. That's what it does. It doesn't do anything else.
It's called parking.
No, yes, it says that you can go out 25 feet from where the boiler room is. It doesn't say that it grants you the right for parking.
The map says parking. So you cannot possibly say as a matter of law one way or another. When the map says parking, there's nothing that specifically addresses it except a prior general, there might be no parking here, right? So you want us to rule as a matter of law. That's what I'm pushing back on you at.
Very well. What I'm saying is what the House Rule 21 does is just completes the circle from what was set forth initially in the speculative risks section that says no tenant shareholder shall have parking. That's what.
So, counsel, looking at the floor plan found in the record at 395, it does say access with respect to the area that we're talking about, accessory off-street parking. It actually says that in black and white.
It does say that, Judge, but sorry. But, Your Honor, the point is that down below, Ms. Atta argued that the proprietary lease in the Second Amendment gave her the right to basically have an unlicensed parking lot. That's what they argued. But there was nothing.
The arguments raised was that this somehow made the area landlocked. Is that accurate?
Well, Judge, to get in, you have to pass a gate to get in. So yeah, I mean, you have to get past the gate to get into the space. But so does everybody else. And also, let's remember something too. 21 also deals with the loading dock. She made a claim that she had the exclusive right to the loading dock. There is nothing in these documents that grants her the right to do that. And there's nothing in these documents that grants her the right to park cars. You know, there's an irony here.
I mean, I think there's also nothing in the documents that prohibits her specifically from parking cars except several years later, and you're relying on documents that are not clear one way or the other.
Well, Judge, I
And
mean,
the question here is whether, in fact, a claim is stated, right?
I'm sorry?
Whether the question here is whether, in fact, the allegations rise to the level of a claim being stated.
Well, Judge, there is, when you have speculative claims as a matter of law, that must fail. And that's what,
I'm not.
What's speculative, counsel?
well, Judge, what's speculative here is saying that, well, let me just say this.
This is all grounded in documentation.
Right, and the documentation, she concedes is paragraph 26 of her own amended petition says that the Second Amendment does not grant her the right to park. Take a look at it. It's in their brief as well. They concede this point, Your Honor. What she's unhappy with is that after spending all these years operating an unlicensed parking lot, somebody put
stop
a
there.
halt
How
to
many
that.
how many spaces do you need to have a license? Before you cross that threshold, it has to be 5, right?
Right.
She's got 4. So how does 4
well,
equal 5?
there's-
How does 4 equal 5?
There's a
Tell me.
point of contention with respect to that, Your Honor.
Really?
Okay? So, but again, it seems to me, if I understand the law correctly, your review is limited to whether there was self-dealing, no self-dealing here, whether there's a legitimate purpose. Everybody's affected the same way. That's just what Justice Reed said.
Except for 21. That only applies to one person. We all agree, right? 21, there's nobody else, the parking.
But there was nobody else who
So
was
that's the one rule. So when you stand here and say it goes to, and that is, even in Lewandowski, that's the ding, 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 I may have stated a claim.
state a claim to get judgment on, or state a claim to
That the
escape
board
from
was acting
dismissal?
in bad faith because only one tenant is affected adversely.
But Judge, there's only
You're
one
claiming you have 100% immunity from liability under the business judgment rule. Lewandowski says, if you can show, if the plaintiff makes a sufficient allegation that this board action affects only one person in a negative way, that is one of the ways that you can overcome the I agree, very lenient treatment that we give boards.
But then what you're doing there, Your Honor, I would suggest, is that you're switching the burden, okay, to show that what we were doing was reasonable. Now, Lewandowski says unless there's language in the House rule or corporate documents that have a reasonableness claim, that it's their burden, it's not mine, and you're making this my burden. And I would respectfully suggest that's improper under these circumstances.
Thank you very much, Counsel. You asked for 1 minute, Counsel, so.
I just have to ask you, but counsel says that you admit that there is nothing in any document that gives you the right to park. That you admit you don't have the right to park.
That's bollocks, to put it in English.
That's a Latin word, actually. Go ahead.
Your Honor,
I just watched Harry Potter. I think that probably was said several times. But go ahead. Yeah, why?
we state throughout our pleadings that there is motive here, that
No, but counsel, that's different. Counsel's saying that you admit you have no right to park.
we don't say that. What we say is that the plan says what it says, and that it's accessory parking, and that we abide by the plan, and that we have been abiding for 29, almost 30 years on a continuous, open, and ongoing use, and that we purchased our shares in a foreclosure sale directly from the original sponsor, who had no reason to and no interest in defining the parking space as accessory or otherwise if it wasn't that.
Except the foreclosure sale documents did mention parking, right? They said, and parking's available or something along those lines?
Well, there are 4 delineated parking spaces, not 5, only 4, and mathematically you couldn't get to 5, and we take issue with the public parking
Didn't
argument entirely.
the commercial listing said there's parking lot space available?
There are spaces, and in fact, from time to time, but it's primarily used for delivery. My client is a nationally acclaimed artist who, her exhibits are massive. They require 18-wheel tractor trailers to bring the
No, we
pieces
read that
in.
with interest, counsel, but it doesn't really go to the issues in this case, so.
The primary use is for deliveries in and out of the loading area. But there is from time to time parking. From time to time, we have allowed the building to put garbage dumpsters and to put other things in those spaces as well. It's been for 20-odd years a friendly environment, frankly, until the current board came in. And it's almost like West Side Story. It really is a true West Side Story where it's a clash of culture versus finance. And that's what we have here, Your Honor.
Thank
And
you
we'd
very much.
ask you to reverse in total. Thank you.
I'll just be brief with regard to, as this court said in the Fletcher v. Dakota case, it's a disjunctive standard. It says arbitrary or malicious decision-making or decision-making tainted by discriminatory considerations is not protected by the business judgment rule. We have pled allegations that we were specifically targeted here on the basis of prior conduct, and that it was arbitrary and malicious to charge a creative photo studio that needs to use the elevator, the freight elevator over and over again, $65 per trip. And not only that, they put together an electronic system for us to register that didn't work. And it consistently didn't work, and that's in the record.
But presumably, there are other people who also use that elevator more than once a day, and they're also getting charged $65, correct?
But not like our clients.
Okay, but maybe your client uses it more, but that is a different story.
But but Your Honor, in the record, it's specifically alleged, and again, it's not rebutted. This is a motion to dismiss without any kind of discovery here that we were specifically targeted on the basis of prior actions. Thank you, Your Honor.
Thank you, counsel. Thank you all. No, counsel, you don't get rebuttal. Sorry. Thank you. DivX v. Harmon. Please.
Thank you, Your Honors. May it please the court. Harmon raises 3 issues of contract interpretation in this appeal, and I'd also like to say a few words about.
You represent Harmon, I
Yes,
presume.
I'm sorry, Your Honor. I
Where's
represent.
your notice of appearance?
I apologize. My name is Adam Unikowski. I represent Harmon in this appeal. Sorry about that, Your Honors. Harmon raises 3 issues of contract interpretation in this appeal, and I'd like to also say a few words about the liquidated damages issue in the cross appeal. So Harmon's first issue concerns the interpretation of the license agreement. In that agreement, Harmon agreed to pay royalties to DivX for every licensed product. The question is, what products are licensed? DivX's position is that the agreement covers sales to all automobile manufacturers. And
Counsel, under the California rules for contract interpretation, how do we not have an issue of triable fact given the and/or language and given the back and forth emails that both parties have given us?
All right, let me address both those points, Your Honor. So the and/or language is expressly subject to this provision, saying that subject to the terms of this agreement, including without limitation the reservation of rights and requirements of set forth in Section 3. So that's at the top of 2 under grant of rights. So this and/or language is expressly made subject to Section 3. Okay, and then when you go to Section 3, there's no ambiguity in the section at all. It says, notwithstanding the
Counsel, you unpack that argument very well in your briefs, but it just seems to make some surplusage, that it seems to mean that licensee agreement means nothing.
So let me say a couple of things about that, Your Honor. So first of all, I don't agree that it makes it surplusage. I think the best way to read this is that it means that in order to sell, it has to either be marked Hyundai or marked Harmon. So if Hyundai resells one of these products to some third party, it has to say either Hyundai or Harmon on it. It has to be a licensee product or a third party. In other words, if Hyundai sells it to Kia or someone else, and that's labeled as Kia, that would be a breach of this agreement. That is how so in other words, that is why licensee brand has independent meaning.
But Harmon is absolutely free to sell to Kia as long as it says Harmon. That's your argument.
No, that's not our argument, Your Honor. It absolutely is not free to do
I'm
that.
mistaken.
Harmon is only able to sell to Hyundai. That's what we're permitted to do. That's it. right? So that's what it covers because the license explicitly says,
But you've
notwithstanding.
been selling to other, I mean, they allege that you've been selling to a lot of other car
No,
companies.
maybe I misstated the argument. Let me try to say it again, okay? It says, notwithstanding the foregoing, licensee may provide in-car units under a third-party in-car brand. So we are only allowed to sell to Hyundai. That's it, okay? So this provision in Section 2.2 recites that solely under a licensee brand and or third-party in-car brand. So suppose we sell to Hyundai. We're good, right? We're allowed to do that, okay? Then suppose Hyundai then sells to a third party, all right? We are obligated to make sure that it still says either Harmon or Hyundai on it. In other words, if we sell in that channel and then Hyundai resells it, it's got to still say Harmon
In
or
this
Hyundai.
scenario that you're putting
Yes.
forward, who's doing that second sale?
It's Hyundai, but we have an obligation to control our licensee. Your Honors, can I just say something about this point, though? I actually, at the end of the day, I don't think it matters if there's surplusage here on our view, even if you think there is, all right? Because number one, I don't think that surplusage can outweigh the unambiguous language that this is subject to Section 3, which unambiguously applies only to Hyundai. And second of all, even if you're right that this is surplusage, and maybe it is, there is tremendously more surplusage on DivX's side of the house. There's this provision that says,
But that just means no summary judgment, no
that is
judgment as a matter of law to either party, and then we go to second step, California law. I mean, you can disagree with me, but that's what I think California law says, and I think most people would agree that once there is an ambiguity or it's not 100% clear, then you go to second step.
so I'm going to say, I don't agree with that, Your Honor. California law doesn't say that even every ambiguous contract goes to the jury, or else many or most contract disputes will go to the jury.
No. It's you look at other evidence.
Yes.
That's what I said,
All right,
right? So looking at the other evidence.
Sure. So the strongest piece of evidence that's cited repeatedly in DivX's brief is this email that says something about a global agreement. That, I think it's cited something like 10 separate times in DivX's brief. I don't think that moves the ball at all because this is a global agreement. It says, for purposes of this agreement, third-party in-car brands shall be limited to Hyundai. Licensee may add additional brands upon prior notice to DXN. So this agreement fully covers the parties' relationship. It only covers Hyundai. We give notice, then it can cover others. It doesn't ever need to be renegotiated. That's completely consistent with saying it's a global agreement, Your Honor. All of that language would be total surplusage under DivX's view. It makes no sense that it would be limited to Hyundai and then we can add additional brands with notice if it already covered all brands in the first place. So if the court is concerned about surplusage, there's a whole lot more surplusage on DivX's side of the house. And I guess I'd like to say one more thing.
One more ambiguity, I think, is paragraph or section 5.4.
Yes.
You want to deal with that?
Sure. So it says that we pay for a license for royalties for in-car units.
Right.
Yes, but in-car units that are subject to the license, like not every single in-car unit in the world, only licensed in-car units. In other words, to the extent we are permitted to sell an in-car unit, then we pay $1 per in-car unit. And Section 3.2 explicitly says we can only sell to Hyundai. So in terms of sending the case to the jury, Your Honor, even if the court thinks there's some ambiguity here, I don't think California law says that every ambiguous or closed case goes to the jury. I know that Your Honor isn't saying that either. I think California law says that you can look at all of the evidence, but you only send the case to the jury when there's credibility disputes. You know, maybe there's a he said, she said at a particular meeting. I don't think that's the case here. Like the primary extrinsic evidence that's relied upon is this one email about global sales, which, as I said, doesn't really move the ball at all. And then there's this declaration, litigation-driven declaration, but fine, that's evidence by someone at DivX, but he doesn't actually say that that's what, Harmon ever represented anything. All he says was he thought during negotiations that this would be global, and then someone at Harmon didn't explicitly rule that out. That's, if you read his declaration carefully, that's all he says. That doesn't clarify, that's not evidence that clarifies the interpretation of this and/or provision. There's really no extrinsic evidence about the and/or provision. So I still think, even if you think it's ambiguous, it's the court that should find the single best interpretation of this provision.
Hey, counsel, just to clarify something, because I was a little confused about our repartee at the beginning. You do sell head units to other car companies, don't you?
We do. So we think that the proper...
All right, I was just mistaken. I just wanted to verify.
We do. If there's a remedy there, those would be unlicensed. So potentially, there's no problem with DivX suing for patent or trademark.
You make that point. Judge Borak made that point. We're
yes,
good.
That's right.
Okay,
so it's just not covered. And we don't think we have to pay royalties at all because we don't think those are patented. They don't say DivX on it. They're not trademarked. They're just free and clear. It doesn't really make... We put DivX certified on products that are sold to Hyundai, and so that's why we paid for those. We didn't put that DivX certified on...
Is it DivX technology?
We don't know. Your Honor, they have not suggested we infringe any patents, any trademarks, nothing whatsoever. That's why they've only grounded their argument in this contract.
Didn't they put in an expert report that said that you were putting in DivX technology and not?
It relies on the
My time's
CTAK.
expired. That's this. I can say one word about this. I see my time's expired.
Go ahead, counsel.
That's the second issue. So there's no actual real allegation that these incorporate intellectual property as defined in this agreement. All it says is it incorporates, quote, packed B-frame technology. That is not an intellectual property right. That's an umbrella description of technology. There's no suggestion that any particular patent or copyright or anything else is actually in this product, and that's an additional reason that is described in the
Counsel,
briefs.
before you sit down, how is DXN technology defined in the agreement, if it is?
It is. It's a defined term. It's defined as the deliverables. That's not at issue. The provision that's at issue is all intellectual property rights in the deliverables. So it has to be an intellectual property right.
But the CTKs are also called deliverables in the agreement, right?
That's right. But but there's no suggestion that the deliverables themselves are in Harmon's product. It's just a bunch of PDFs and videos. So the only issue in this case that has been raised by DivX is that the CTKs actually contain intellectual property rights. That's the sole allegation that's been made. All right.
Okay.
And so our second argument on appeal, I realize my time has expired.
Well, you can deal with it on rebuttal.
Right, thank
Thanks
you,
so much.
Thank you, Your Honor. Joseph Palmore for DivX, respondent cross-appellant. The Supreme Court got it right on liability, but erred on liquidated damages. Turning to the first issue, the Hyundai issue, the Supreme Court correctly denied summary judgment. We did not appeal the denial of our summary judgment. We are not asking for judgment as a matter of law on this question. We agree that this should go forward. And under California laws—
Counsel, let me ask you this about the notification agreement, you know, that you're supposed to notify, they're supposed to notify you if they have a deal similar to the Hyundai deal. Does that undercut your argument?
No, it doesn't, Your Honor, because the fact that they didn't notify us and probably should have doesn't get them out of paying royalties, right? All of these units, and critically, the court's questions went to this, they either under a licensee brand and or a third-party in-car brand, right? So it could have a Harmon branding, it could have a Hyundai or another car's branding, or it could have
You're
both.
saying they all have your licensed technology.
That's the second issue, absolutely, because it's a very
Because
broad—
counsel's saying they don't.
Right, that's the second issue. It's a very broad definition, and I think that this is really important. There is a patent license agreement in this record. That's the Samsung agreement, which is the third issue. I know there are a lot of issues here. And if you look at that, what it says is you can manufacture or sell products that would infringe a list of patents, but for this license agreement. That's how you draft a patent license agreement. This is very different. This definition of intellectual property is very broad. It includes not just patents, it includes trade secrets, know-how, technical expertise, things like this. And then a licensee product is a licensee product if it incorporates some or all of this, this technology or its derivatives. This is the parties here were entering into a business agreement where they were going to allow Harmon to use DivX's inventions, its technical expertise. This was not a patent licensing agreement. So the Supreme Court correctly denied summary judgment on that question too. Again, we're not asking for judgment. We think this should go forward. There's a factual dispute about whether these Harmon products do incorporate the technology or not, and that's for the trial.
But how about counsel's argument that it applies only to Hyundai?
Right, so that argument reads out the and/or. The section 2.2, which is the relevant licensing provision, says that it can be sold under a licensee brand, which is Harmon, and or a third-party brand, which is Hyundai. And he doesn't really have a proper explanation of that language. He strikes it affect the agreement. He relies on the last sentence of section 3.2, but of course, in California, as here, contracts are to be read as a whole and not to be kind of self-canceling or strike out other parts of the contract.
So how do you read that?
Yeah, so if you look
Particularly
at
with respect to the last sentence.
Yeah, so I think if you look at Romanet, Little Roman 4 of 3.2, it's a flat prohibition on any kind of third-party branding. So what I read that last sentence to have done was to clarify that now there is a permissible kind of third-party branding, but it certainly doesn't cancel what was expressly stated in 2.2, which is that sales under the licensee brand are also covered licensee products. But again, if you think that there's some kind of tension or contradiction there, then under California law, you look to the extrinsic evidence. And the extrinsic evidence is quite, there's ample extrinsic evidence on DivX's side that this was meant to be a global agreement, not global just in the sense of the whole world, but for in-car. And the Potter Declaration says that while, yes, they specifically mentioned—
In-car Harmon brand and other cars that besides Hyundai.
Yes, they would. That Potter's declaration says, and there are contemporaneous emails as well that support this, that what DivX wanted and what the parties were discussing was a expanded agreement that would extend to in-car, not just Hyundai. Now, my friend on the other side says this isn't credible, it's self-serving, this came up after the fact. That's a fact finder argument, right? Under California law, the only—
Counsel, should we talk about liquidated damages?
Yes, Your Honor. This is the one part of the Supreme Court's decision that we think was wrong. California law actually favors enforcement of liquidated damages provisions, and it places the burden on the party that seeks to nullify the provision to show that it's unreasonable under all the circumstances, including the sophistication of the parties. Here you have two of the most sophisticated parties that you're gonna see in a dispute like this. This agreement was negotiated for 5 months. Both were represented by counsel, and they agreed to this provision. We put forward evidence, even though they bore the burden, that there were reasonably foreseeable special forms of damages that could result from a breach of the obligation.
They were hard to quantify.
That they are hard to quantify. This is a unique case in which there is a very complicated licensing ecosystem that DivX—
You say that one of the hard to quantify harms that's possible is the likelihood that other vendors in the supply chain will be incentivized to underreport usage. Can you unpack that?
Yes, Your Honor. So DivX licenses its products to many, many consumer electronics companies like Harmon. This is a complex licensing ecosystem, right? And so if the word got out that DivX isn't enforcing its royalty—
okay, so another supply chain, not this particular supply chain going to—
No, it's if the word gets out in the market that you can get away with cheating DivX, then that will have all kinds of downstream knockoff effects. And
they find out though.
If they find out about it, yes, but they could. It could be reasonably foreseeable that they could. They also— DivX had to engage in a lot of investigation. We cite this in the record as well. One employee just himself had to spend 150 hours investigating.
Do you get paid for your audits though? I mean, if you have to do an audit.
So the audit, we're not suggesting that the expense of the audit itself. There was an investigation before the audit that was quite expensive that DivX had to undertake in order to detect this cheating, and then that led to the audit. So there is evidence in the record showing that harms beyond the simple failure to pay royalties could have reasonably been anticipated. And I would commend to you the California Court of Appeals decision in Gormley that we rely on. That's the most recent California case of all the ones that are cited by the parties here. And it makes clear that enforcement of these provisions is favored in California, and you look at all the circumstances, including the sophistication of the parties.
Thank you very much, Counsel.
Thank you.
You have time to rebuttal as well.
Thank you, Your Honor. I'd just like to make 2 points. One is just to wrap up the discussion of intellectual property rights. So that's a defined term in the agreement. It's true, as my colleague says, it's very broad. It covers things like trade secrets. The problem is there's no trade secrets at issue in this case. The only type of intellectual property, actual intellectual property, not Pact B frame technology, which is a very general term, but actual intellectual property that's ever been mentioned are these patents that were described by the expert of DivX in the trial court. The problem is that there's no evidence that these patents are either incorporated into Harmon's products or in these deliverables. That's why there's this slippery term being used, Pact B frame technology, but that's just not an intellectual property right, and this defined term requires an actual intellectual property right, not just a generalized description of technology. I just want to say one word about the liquidated damages issue. We think the trial court did get it right on this, And the Ridgely case, which is a California Supreme Court case that authoritatively sets forth California law, I think is dispositive. The court says liquidated damages clause will generally be considered unreasonable and unenforceable if it bears no reasonable relationship to the range of actual damages that the parties would have anticipated would flow from a breach.
Was the trial court under the misapprehension that it was 3 times damages rather
Yeah,
than
it's
2?
2. I don't know why the trial court said 3.
I mean, could that affect its analysis, though?
I don't think so, Your Honor, because I think even the theories that have been offered for why it's reasonable really don't make a lot of sense. Like if you breach a royalty agreement that damages the amount of royalties and maybe the time value of money, which is explicitly covered in
Or
this
how about goodwill?
I don't understand how not paying royalties would influence goodwill. Maybe, mismarking something, breaking a trademark agreement, that might be a problem.
But I mean, isn't that a permissible way? Isn't liquidated damages a permissible way to cover goodwill, marketing, all kinds of things that are very hard to quantify?
Yeah, perhaps so, but this provision is a royalty payment provision. It's an agreement to pay money. It's like, you borrow money.
That's all, everyone.
that's
I
not
mean,
true.
that's
This
the way it is with the
No, Your Honor.
counsel. If you speak over me, I'm the only one who can, I can't hear what you have to say, and I know you want me to hear you. So, I mean, that is true of liquidated damages provisions in many situations where some of the damages are quantifiable, but some are not. So I don't know how you could say as a matter of law, this is one of those cases where it doesn't apply.
Your Honor, this is an agreement to pay royalties. That's all it is. Okay, so if we don't pay the royalties, the harm we have caused is the payment of royalties. There's no goodwill harm. This is a private agreement. We're not broadcasting to the general public whether we're paying royalties. So there's this argument that there's rumors might go out and people might have heard that we didn't pay royalties, and they'll say, well,
So then why would 2 sophisticated people put in a liquidated damages provision if there was no possibility that there would be damages that were not easily quantifiable?
It's a penalty provision, Your Honor. It only applies if it's discovered in an audit. It's essentially a penalty provision, and the Ridgely case holds that that's not enforceable, even with sophisticated parties.
Thank you, counsel.
Just a couple quick words on liquidated damages. Again, Gormley answers a lot of these questions. In Gormley, it was a late payment case. The party there was owed $575,000, and there was a provision in the contract saying if you don't pay on time, it becomes $1.5 million. That actually was nearly a tripling. And the court enforced that because their parties were sophisticated, they were represented by counsel, there was a connection to possible harm, and we have all of that here as well. We do have evidence, even though they actually bore the burden and put in no evidence at all that this was unreasonable, and they did agree to this. This was not a form contract, a contract of adhesion. This was negotiated over 5 months. If they didn't want to be subject to this liquidated damages provision, they should have negotiated it out of the contract. Thank you, Your Honor.
Thank you. Thank you both. Our last case is People versus Ferrera.
Good afternoon, Your Honors. Ronald Zapata with the Office of the Appellate Defender for Mr. Ferrera. Before getting to the substantive argument, I am asking this court to again reconsider its decision to withhold complete grand jury minutes from the defense. Without the complete minutes, I cannot intelligently and effectively review the grand jury claims on behalf of my client. Significantly, the only minutes apparently weren't provided to me were the prosecution's instructions to the grand jury, which the prosecution has provided no reasonable basis not to provide them. Apparently, the only reason not to provide them would be to insulate their instructions to the grand jury from any defense scrutiny.
Counsel, I think you made your record on that. You made your record on that in your brief.
Yes, Your Honor.
Please, why don't you go on to the merits?
So in terms of the substantive argument, to the extent I can make an intelligent argument about that, it appears that the prosecution impaired the integrity of the grand jury proceedings.
Counsel, you're talking really fast.
I'm sorry, Your Honor. First, the prosecution does not contest, they improperly had a non-eyewitness identify Mr. Ferrera from a video.
Do we have a waiver issue to start with?
No, Your Honor, because as the Court of Appeals in People v. Manrick stated a impairment of the integrity claim is not waived if there's a
This is
constitutional issue
more of an,
regarding.
I mean, could one define it as an evidentiary matter? And if that's the case, is it not a mode of proceedings error?
If it is only an evidentiary matter. But as the Court of Appeals in Manrick had stated, first to decide whether the case involves an impairment of integrity, you have to look at the substance of the argument first. So you can't just not look at the substance without deciding and finding whether the integrity of the grand jury proceedings has been impaired.
Yeah, but I mean, here you have, I mean, yes, Feely should not have described the defendant or use the term, that's the defendant in the video, but there's so much else here that the grand jury had to go on.
Well,
starting with a confession, right?
Well, in terms of, there's a problem with the confession as well, but I would say either or, in terms of an impairment of the integrity claim, it's important to note that the prejudice standard is much lower than a harmless error standard. You only have to find a possibility of prejudice. And here, where the video is absolutely no way that anyone could identify who that is.
What if in the grand jury, I don't say this happened or not, but what if he said the defendant identified himself in the video, and then he went on to describe the person in the video as the defendant? That's a hypothetical. What would be the case then?
Then that would be fine in terms of him saying, okay, the defendant, if he says the defendant told me that that's him,
yeah, right.
Yeah, that would be fine. He's still not allowed to narrate what happened in the video, which is what he did here. He's saying that, oh, you could see that he's opening a garbage bag and he's pouring gasoline in there. That's still improper under Mosley. So I would argue that creates a possibility of prejudice, but also the prosecution violated their duty of fair dealing in terms of the statement as well, because they only elicited the inculpatory part of the statement, but not the full part of the statement, which also included an exculpatory part.
Why would you think that Mr. Ferreira's statements were exculpatory? When he said that it was Passover, there was nobody living in certain apartments, or the apartment in the fire, where the fire was set, why is that exculpatory?
Because he's saying he did not mean to harm anyone. He did not know that people were in the building. And so that's exculpatory for an arson and a second-degree claim.
But to the extent that it's juxtaposed with his inviting the tenants to come down to look at the fire that he had just set.
Yes. Well, the knowledge of having someone there has to be at the time the fire is set. So him afterward saying, oh, I saw a tenant there, and he actually goes to that person's apartment and brings them down, actually is exculpatory itself too.
That's exculpatory?
Yes, because he's...
That contradicts the first statement.
No, it doesn't, Your Honor, because it's a different apartment.
Nobody's in the building, but, or is it nobody's in the apartment?
It's a different apartment where that person is at. So he's saying he doesn't know people are there at the time that he set the fire. Then afterwards, when he gets out of the building and apparently sees someone's in there, he goes there and tells the person, hey, come down. He's actually trying to prevent any harm from the person. So that's exculpatory itself. But the problem here isn't just whether that evidence should be credited or not. It's that it has to be presented to the grand jury. It's not up to the prosecution to decide, okay, I don't credit this testimony, therefore I'm not going to give it to the grand jury. Once that evidence is put together in the same statement, in their duty of fair dealing, they have to provide both statements to the grand jury to make that determination. And they did not do that here, and therefore they violated their duty to fair dealing.
Thank you, counsel.
Thank you.
Time rebuttal.
Good afternoon, Your Honors. Jacob Marcus for the people. I'll start with the waiver issue that Justice Moulton brought up. I think that this claim is waived, forfeited, and unpreserved. The Court of Appeals has kind of distinguished what's jurisdictional and what's not. This is a claim of evidentiary or technical error. It's not the kind of overall pattern of willful, pervasive prosecutorial misconduct that it identified as jurisdictional in People v. Thompson. It's not a hollow indictment. It's not one that was improperly submitted to the grand jury. So I really think that the claim is foreclosed from this court's review. To turn to the merits, with the evidence that the people adduced with regard to Fire Marshal Feely's investigation, both security footage, both the indoor and the outdoor, which served to corroborate defendant's confession of the crime, that was sufficient. Obviously, the people admit that Fire Marshal Feely should not have identified defendant in the grainy outdoor surveillance footage. The prosecutor should have stepped in and stopped that identification. But setting that testimony to the side, the grand jury still would have drawn the inference of guilt. I'll note that this is a reasonable cause standard because it is just an indictment, not a conviction at trial. If Your Honor.
So, but your adversary says there were exculpatory statements there, and why didn't the jury have a chance to hear them? I don't know that they were exculpatory, but they were statements nonetheless.
Right, I don't think they were exculpatory statements. Arson in the second degree does not have an intent to harm requirement, so his statements that I didn't mean to hurt anyone really don't bear here nor there on the charged crime. With regard to the statements that 3 of the apartments, that's I think 1H, 1J, and the empty supers apartment were vacant, that has to be understood in context that this is a 70-unit residential building. So the fact that 3 of those 70 units were empty doesn't turn that into exculpatory evidence that he didn't have reason to know that anyone was in this 6-story building. And again, the fact that he goes to Braunschweiger's apartment immediately thereafter, while of course the knowledge does have to be contemporaneous with the fire, this at least allows the grand jury to infer that he knew someone was there. So since it's not exculpatory, it doesn't have to be posed to the grand jury. I think the challenge with one statement is really that the people have to avoid excision or editing of a statement. This isn't what happened there. I think, to use the language of this court in Townsend, the prosecution fairly synopsized, or had the witness fairly synopsize the statement, and that's all we were required to do here. So unless Your Honors have any further questions, we ask that you affirm.
Thank you, counsel.
Just a few notes. As this court knows from its many appeal waiver claims that he reaches every day, you can't waive anything that's been forfeited by guilty.
But doesn't that basically, in this context, have to be that the prosecution literally puts forth one lie and nothing else? I mean, that's the Court of Appeals case you're citing, right?
I'm sorry, can you repeat that?
The Court of Appeals case you're citing is where the prosecution puts forth knowingly false testimony and nothing else, right?
You're talking about Manrick?
Yeah, I'm talking about when this rises, when you don't have to preserve this type of claim, right? Well, it has to be jurisdictional, and the Court of Appeals, it says, it becomes jurisdictional where in this extreme circumstance where the only evidence there is knowingly false testimony and nothing else. We don't have that here, right?
The Court of Appeals has never stated that there has to be knowingly false testimony. If you look at the language in Manrick, it states that constitutional issues, including the prosecutor's violation of a constitutional duty to fair dealing, is a argument that is not waived or forfeited by guilty plea.
And fair dealing in the cases, there's basically putting forth false testimony, right?
That's one case. That's not
okay, what else could you? What else?
Well, I would argue like
this,
yes.
Not stopping someone from making identification. You're saying it rises to the level of a jurisdictional defect?
The Court of Appeals has stated that one type of error that's a violation of fair constitutional duty to fair dealing is when the prosecution chooses one part of a statement and not the entire part of a statement when there's exculpatory evidence there. That is, I have a citation.
No, I know. I understand what you're saying.
Yes, Your Honor. And so if they're stating that in one case and then they're stating in Manrick that principle holds for the integrity of the grand jury, obviously that's not forfeited here as well.
Right.
So, yes, unless you have any other questions.
Thank you, counsel. Thank you both.
Thank you.
You too.